signed. Committee Room 30, 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 Committee Room 30, signed. 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 Signed. Committee Room 30, 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 Sound. 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 Committee Room 30, Sound.
That's us. We're now in public session. Who's joining us, welcome to the 7th meeting of the Committee for Justice. I'm not sure if anybody is due to join us from outside, but I would advise members that the committee meeting is going to be recorded and broadcast throughout Parliament buildings and online. Obviously, as ever, those in the public gallery are welcome to use mobile devices, and you can connect to the Assembly Wi-Fi, but everything should be muted, and there's no permission for photographs or recording of any part of the meeting. Just to reiterate in public, members, that Justin McNulty, Alex Easton and Sinead Ennis are attending the meeting virtually. It's proposed that the oral evidence session with Dame Brenda King, who is the Attorney-General for Northern Ireland, and the oral evidence sessions with the Department of Justice officials on the overview of the Safer Communities Directorate and on the proposed legislative consent motions for the Criminal Justice Bill will be recorded by Hansard. Are members agreed?
Agreed.
Thank you. Also, members, just in terms of housekeeping, we're obliged to declare any financial or other relevant interests which might reasonably be thought by others to influence our approach to matters under consideration. Anybody who has any interest to declare in relation to today's business should do so now or when the particular matter arises in the meeting. Does anybody have anything they wish to declare at this stage? No? Well, could I declare that I have an immediate family member who works in the legal profession? So agenda item 3 is the draft minutes of the meeting held on the 21st of March 2024, which are at pages 33 to 40 of your meeting pack. Are members content that the minutes are a true and accurate reflection of the proceedings of that meeting?
Agreed.
Thank you. In that case, I will sign the minutes. Items of any matters arising. Does anybody else have anything they want to raise that's not included in the agenda? No, then we're fine. Thank you. So agenda item 5 is the Attorney-General for Northern Ireland, and I would refer you to pages 43 to 54 of your meeting pack for the relevant papers. The Attorney-General for Northern Ireland and her colleagues are going to be in attendance. Dame Brenda, thank you very much for coming. So I would welcome Dame Brenda King, who is the Attorney-General for Northern Ireland, Ian Wimpress, Solicitor for the Attorney-General, Maura McCallion, Division Head, and Orla Ward, Division Head of the Office of the Attorney-General for Northern Ireland. You're all very welcome, and thank you for taking the time to come and brief us today.
Thank you very much, Madam Chair.
Thank you. I will hand over to all of you for your remarks and for your briefing, and then presumably there'll be time for questions at the end. So, and I do apologise to have kept you waiting there, but I appreciate we had some procedural issues to deal with, so thank you very much.
Absolutely, we appreciate it. Well, thank you very much again for your invitation to come and address the committee today. I'm very pleased to see you all as new committee members, and some of you I know from my 33 years around Parliament buildings, and some of you I don't, but I'm sure I will by the end of the mandate. You will have an awful lot of challenging issues to address during the very short remaining years of this mandate, and I wish you well with that, and I'm sure our paths will cross again. I particularly welcome this invitation to brief you because I think not enough is known about the role of the Attorney-General, and oddly enough sometimes not by lawyers. We tend to focus on those areas of the attorney's roles and functions that interest us, or the areas of work we're involved in, but not the wide range. So I'm hoping today to give you an overview of what all of those functions are, and some of them you will be more interested in than others, but it's important to I think go over all of those. So accompanying me today I have all of my senior lawyers here. We're a very small team, and you've already introduced Ian Wimpress, Orla Ward and Maura McCallion, and I'm very grateful for their help. It is unusual that Attorneys General are appointed for a period of 5 years or less, so you can have an Attorney General perhaps appointed for a short period of time, a shorter period than that, and it's really important that you have a good, stable office and structure to support the Attorney General, who may very often be coming from the independent bar and will be less familiar perhaps with the machinery of government procedures. So I'll just say a little about the origin of the role of Attorney General, because it is quite different now from 2010 onwards. So the Justice Act, Northern Ireland 2002, which you'll all be terribly familiar with, is a useful starting point. So we've had an Attorney General in Northern Ireland since 1920, and prior to that, of course, we had an Attorney General for Ireland. And throughout the period from 1972 to 2010, which you must remember was a period of 38 years, there was no locally based Attorney General, and the Attorney General for England and Wales carried out those functions. And I think that has led to the perhaps obscurity of the role, because when you don't have someone actually here and in place, that makes a big difference. So the Justice Northern Ireland Act 2002 provided for the devolution of justice to the Assembly, of course, and the Executive, but did not really come into operation until 2010. So really we have only had 14 years experience of the new rule, with only 2 local attorneys general in place since then. So the new rule, of course, encompassed all of the new constitutional powers set out in the Northern Ireland Act 1998, particularly in relation to scrutiny of Assembly bills and work with the Assembly, but of course those didn't fully come into operation. Those functions were carried out by the English attorney until then. But a significant feature of the role, the new role, was that the previous prosecution functions of the Attorney General for Northern Ireland were removed and transferred to the newly established Public Prosecution Service and to the Director of Public Prosecutions. So the Attorney General has since 2010 or 2002 had a reduced role there. So there are many statute provisions on the Statute Book of Northern Ireland prior to that referred to having the Attorney General's consent to prosecute, and prosecutions being taken by the Attorney General, and those have now gone and are with the DPP. So I still, though, have a very large number of what you might call residual, but they're still very substantial criminal justice functions. So the main ones of those really relate to the appointment of the DPP, and I'll come to a bit more about my relationship with the Director of Public Prosecutions a bit later. The issue of human rights guidance to a range of bodies having criminal justice functions, and that will probably interest you as a committee, and consultation and interaction formally with a wide range of criminal justice organisations. So I think it is the move from the wider criminal justice role that was there previously and the current role that creates quite a lot of confusion. I still would get correspondence from members of the public asking about lenient or what they perceive as being unduly lenient sentences, and queries relating to prosecution decisions taken by the DPP. And as I say, I think that relates to not as much being known about the role as should be. I think it's a really important part of the devolution settlement. We do have our own Attorney General for Northern Ireland, and the architecture of the whole devolution settlement fits with that. So I've been keen, while I've been in office, to speak to a wide range of organisations, and if there are any of those that you think about would be useful for me to speak with, I'd be very happy to do that and engage with others. So if it would suit you, I thought I might divide my description of functions into 3 sections just to make it easier. Those would be my general functions and responsibilities, which, while they might not directly relate to the matters you normally deal with, a lot of them will. And then my particular functions in relation to criminal justice matters, and then some new and recent functions which have been conferred on me, which you may not be aware of, and I'll try to explain those. So the first important thing to say is about my independence, and this is a very unusual feature of the role here. Section 22 of the Justice Act requires that I exercise all of my functions independently of any other person, and that is a very important obligation to ensure my political independence. So although I'm appointed by the First Minister and Deputy First Minister, it's perhaps a political appointment, you might call it that way, of a very non-political person, and that is different to a lot of Attorney General roles elsewhere. And I'm prohibited, of course, by standing for election to Westminster, this Assembly or a district council, which is not difficult for me to follow, being very apolitical personally, but very interested in politicians and very admiring of what all of you do and your stamina. So I don't make policy, although I advise ministers on the executive of the legal implications of the policies they are developing and delivering. And I think there's a greater complexity to this role here in Northern Ireland than perhaps elsewhere because of the nature of the power sharing arrangements here. But I feel that giving advice to ministers at a very early stage helps with consensus and agreement across the range. One of the first things that I did was to draw up a full list of the functions of the Attorney General, and I think the clerk has circulated that to you all. I thought it was useful to do that. And I do, of course, compile an annual report on how I've exercised my functions, and we have 2 of those to lay very soon. We didn't have, those are laid by the First Minister and Deputy First Minister, and with those ministers not being in place, we haven't been able to do that until now. So talking about my general functions, one of the most important roles I have is that of Chief Legal Advisor to the Executive. So I'm called on to provide advice to ministers and the Executive on some of the most difficult and complex issues on a day-to-day basis. So not just at the Executive, but as those arise from time to time. And these are very often issues where there is no legal precedent or guidance. So I'm entitled to attend executive meetings. There was one this morning, of course, and give advice to ministers orally at those meetings, but I also give written advice and opinions as well. I don't attend all executive meetings, although I may attend a lot, one after the other. It just depends on the areas that are coming up for discussion. But I've had many years of experience in the constitutional legal world and have advised departments and ministers really since 1998 and involved in the implementation of the Good Friday Agreement. I've held 2 international roles which have been interesting politically while not being a politician, and I was First Legislative Counsel from 2012 until 2020. So I'm very used to dealing with legislation. And I'd like just to pay tribute to Alec Gordon, who is acting First Legislative Counsel while I am Attorney General. I'm very grateful to him. It's a very few Legislative Counsel worldwide, so important that that role goes on to serve the Assembly. So I receive copies of all executive papers and I will comment on those. As you can imagine, that's quite a demanding task in its own right. And each Northern Ireland Minister and Department has, of course, recourse to its own legal advisors, and you might be interested in hearing a bit about the relationship there and how that works. But I would be called on to advise on really the most complex matters, including where there might be disagreement between ministers on different views, or perhaps differing legal opinions have been obtained on a particular issue. But during my time in office, I've agreed a protocol with the Departmental Solicitor's Office so that I can access the background information that I need to know to be able to advise on those cross-cutting issues. And I will mention something that's often forgotten, and that is the long-standing constitutional convention, the convention that not only is the advice given by the Attorney to ministers not to be disclosed, but it should not even be revealed that the Attorney has been asked to advise on a particular issue. This is important, and it's known as a Law Officers Convention, because we need to provide space for ministers to discuss freely their policies and ideas, and I think it is particularly important in our devolved government, as I say, to reach consensus on different issues. And I have been dismayed in the past when my advice has appeared on the front page of some publications, which would be really unheard of. elsewhere, because it may deter ministers from seeking. So I think that's quite an important constitutional protection to have there. So that also means that I may not be able to answer all of your questions which relate to legal issues that I've been advising on, maybe advising on, but I will try and help you as much as I can, both today and in the future, if there's anything that I can do for you. And I have in the past assisted the committee on different issues that have arisen. But you'll all know that one of my most significant statutory roles is in relation to advising on the legislative competence of Assembly bills. And just to remember, that does cover both executive bills and private members' bills, although I may not see private members' bills until maybe the very last minute or when those are introduced. But with executive bills, there's a lot of engagement at the early stages, so if I spot anything that may be problematic, those issues can be ironed out. And so obviously I'm looking for bills which go into the reserve or the accepted areas, and now of course provisions which may be in conflict with Article 2.1 of the Windsor Framework. So that's a new rule. The convention rights, looking at those very carefully, and a number of other factors. I know you're going to spend a lot of your time scrutinising the many criminal justice bills and justice bills that will come your way. And I know the size of these, and often they are omnibus bills, are going to take up a lot of your time, and I wish you very well with that. I also have, the point of this really is that I have a power under Section 11 of the 1998 Act to refer the question of whether a bill is within competence to the Supreme Court for decision. So I scrutinise every bill in detail, obviously before deciding whether I'll exercise that power, and it really shouldn't happen very much in practice, or at all in practice, if there has been good engagement at an early stage. And often the issues will arise where a bill inadvertently touches on another area of law, but that is not recognised. So as I've said, I will look at those executive bills early, and I'm open to members also engaging at an early stage if I can. I have the capacity to do that. You'll be aware that I have exercised my referral power on one occasion, so it was fairly exceptional. It did come at the very end of the Assembly mandate when I referred a provision of the Abortion Safe Access Zones bill to the Supreme Court. And Maura might like to say a little bit about that later on, because Maura was there in the Supreme Court when the judges decided on that. So that was really, if you remember, the one clause of the bill created a number of offences which could be committed within a safe access zone, including impeding access to premises or causing alarm or distress. So the Supreme Court was actually only asked to consider just one of the offences and one provision, and that related to influencing, which is a fairly flexible concept, as opposed to causing alarm or distress, impeding access. So the issue which arose was whether there was an appropriate balance between the Article 8 rights to private life of those accessing abortion services and the rights of freedom of assembly and expression of those who wish to protest in a way which does not cause distress. So that was determined by the Supreme Court, and they did welcome the reference, and they decided that balancing the competing considerations, the restrictions on convention rights, are justifiable and therefore within the Assembly's legislative competence. That was a bill where if there had been uncertainty, there probably would have been a lot of litigation in the court, so it's very useful to get the court's view on that. And they actually used the occasion to review case law in relation to protests, which they found useful as well. I also have a role in relation to general litigation in the courts, particularly where there are constitutional or other matters concerning the public interest. And Ian is the solicitor to the Attorney General, so has charge of filing all documents on my behalf before the courts, from the highest to the lowest. I'm put on notice of any court case in which a devolution issue under the Northern Ireland Act arises, and you'll be aware of those as well, and I may participate in the litigation. And different Attorneys General will take different views to participating or initiating litigation. In relation to each of these cases, I read the papers very, very carefully to decide whether I will intervene or not. I will normally not intervene, and this is simply my practice, if the matters arising in the case have, in my opinion, already been adequately covered by the parties to the case. I'll always look for gaps. I may also intervene if executive ministers would like me to intervene on their behalf or to support them, perhaps with supplementary submissions or observations. And I will also intervene if I don't think the issues have been adequately covered or the issues relate to a particular responsibility of mine, which you'll hear about a bit later. So I may also lead on litigation arising from a matter that I have provided advice on, if the executive wishes me to do that, but that will normally be led by the lead department. The departmental solicitor's office will take the lead on that. So it's really a matter of judgment. I can also take legal action in the public interest if certain types of contempt of court appear to have been committed, or to obtain a declaration that a person is a vexatious litigant. That doesn't often occur, but it is an important way in which to support the courts. So vexatious litigants are people who repeatedly litigate when earlier litigation has been unsuccessful, and on any rational basis the time has come to stop, and the courts are really getting very clogged up by unnecessary applications. So I can make application to the High Court under Section 32 of the Judicature Act 1978 in relation to those cases as and when required, but quite often a warning is simply enough. It does support the judiciary. I'm also quite rarely placed on notice of proceedings where there is a declaration of incompatibility in relation to the Human Rights Act in respect of primary legislation, or where the compatibility of secondary legislation is being challenged, and I can participate in those proceedings. There's just been one recent example of this, which related to the Children Order 1995, and the point there was not so much the substantive elements of the litigation, but whether the Children Order, which was an order in council, was primary or secondary legislation. And that's not an easy question to answer unless you're fully aware of all of the provisions of the Northern Ireland Act. I also have a lot of functions in relation to the protection of the public interest in court or tribunal cases relating to charities, and Ian would handle a lot of those. So that can involve proceedings before the charity tribunal, for example, where it's impossible to distribute the funds of a charity when the original purposes no longer exist. So I make legal submissions to the charity tribunal or the High Court, but very often those might be in relation to issues of statutory interpretation, which are quite complex, or the reading of very ancient documents setting up a charity. And sometimes my consent is required before certain proceedings are issued, usually relating to the law of charities, or to enable someone who wishes to enforce, typically by injunction, a right which belongs to the public as a whole, rather than having a private nature. But those are really quite rare. And also a function which I don't think has ever been exercised is my role in relation to missing persons who are presumed dead. And I also have, which is quite interesting, since I drafted that legislation and never thought I'd be Attorney General having a role in relation to it. And I also have a role in relation to declarations as to matrimonial status. Again, that's quite rare. And parentage, which does arise from time to time, of course, is of more interest now than it has been before. One of the areas that will probably interest you will be my powers to direct coroners to direct an inquest, and that of course very much affects the court system. So I have a power under section 14.1 of the Coroners Act, Northern Ireland 1959, to do that, and that is very broadly drafted, so I can direct a coroner to hold an inquest into a person's death, in essence to find out how a person's death came about. In some cases the coroner will look at the broader circumstances beyond the immediate cause of death, but it's usually fairly limited. And again, I had a case before the Supreme Court last year in relation to an inquest case to clarify the time within which certain proceedings could be taken. So the court ruled on that, and we can say a bit more about that if you're interested. But again, the Supreme Court welcomed the opportunity to clarify the law. So, as I've said, it's a very wide power, and really it turns on whether it is advisable or not to direct an inquest. So that may vary from case to case, and my office receives a large number of applications each year from a range of parties, including the next of kin of the deceased or solicitors acting on their behalf, as well as representatives of victims groups and others. And I have to say, I find that personally probably the most difficult part of the role, because of course the victims' families have suffered, or the person who has died, their family has suffered, and you would love to be able to direct an inquest on all kinds of cases, but you exercise your powers within a range of parameters. But one interesting thing is that a decision not to direct an inquest is never a final one, and I often receive renewed inquests. When I was appointed as attorney, there was an influx of new applications where the previous attorney had taken decisions not to direct an inquest. There were renewed applications, so that's quite an interesting thing. I think when you have a new attorney appointed, you probably get a lot more of these. And in some cases, of course, where there is a likelihood that someone may be prosecuted, I will refer the matter to the DPP or the PSNI. So there's a range of things that might happen there. So I consider these applications in great detail and have a look at what material was available to any previous inquest, and any new information that might be available, amongst a lot of other things, and whether witnesses will still be available to give evidence, and importantly the utility of holding an inquest and what that might add to what is already known. But the inquests, of course, which attract most attention are those which are described as the legacy inquests, and as you know, my powers will be coming to an end at the end of this month on that. But I would emphasise that those only form part of the inquest workload in my. We have a lot of other inquests which relate to all kinds of causes of death, and that will keep us very busy. So the introduction of the legacy bill, I'll call it that because that's, and it's now been enacted of course, but the introduction of that bill resulted in a large number of applications coming to the office really at very short notice. So that has taken up a considerable amount of my time and my team's time and resource to ensure that all of those requests are dealt with before the 1st of May. And it has put quite a strain on the office, particularly since the office is very small, and we've been able to cope with things while we didn't administer it in place, but that is very much changing. So like every area, we're a bit short on resources and funding, but I'm not going to make a plea for any of that now. Another interesting thing is that when I decide not to direct an inquest, that decision may be judicially reviewed, so that's another volume of work, and indeed that is where the Dalton case arose from. So I think I have covered that in a good bit of detail, and I've mentioned the DPP earlier, so we'll say a little bit more about that. I appoint the DPP, or rather the attorney does. I keep talking about myself in the third person because it is an office. Brenda King, am filling it at the moment, but I'm the Attorney General and I have these functions which are, as I say, official functions. So I appoint the DPP when a DPP needs to be appointed, but I have no supervisory superintendent's role as regards the DPP. DPP will consult with me, but beyond that really there is, and I informally engage with the DPP as is right in relation to criminal justice matters, but it's a more limited form than that would have been before. I am consulted by the DPP, and this is a statutory requirement, on amendments to the code for prosecutors, and I lay the annual report of the DPP before the Assembly. And obviously the human rights guidance that I issue will also apply to the PPS in relation to the exercise of its functions. So that does take up time when those issues come up for renewal. The human rights guidance that I issue will be of interest to you as well, because obviously you will spend time scrutinising that when new guidance is issued. So I have a duty under Section 8 of the Justice Northern Ireland Act 2004 to produce guidance for criminal justice organisations on the exercise of their functions in a manner that is consistent with international human rights standards. There are 14 sets of guidance in place, and I am currently reviewing these to see whether there's a need to revisit any of the guidance or indeed to issue fresh guidance on new topics. And this can be found on my website, and as you know, it covers issues such as prison standards, support for victims and witnesses, restorative justice, retention of biometric material, and importantly, domestic abuse and stalking. And the criminal justice agencies such as the police, the PPS, the court service, the prison service must have regard to that when they carry out their functions. So there may be engagement with you if there is new guidance to be laid in this mandate. And I mentioned earlier that, and I'm coming to the end, you'll be very glad to hear some of the relatively new functions that have been given to the Attorney General, and I am sure that there will be more coming down the line once ministers get into the process of bringing forward legislation and getting that enacted. I have a number of new functions as a result of the UK's exit from the EU. I will of course be scrutinising Assembly bills, which now, instead of the having to comply with EU law, it will be Article 2.1 of the Windsor Framework that we'll be looking at. So that is a change to legislative competence, slightly narrower. I've also been given new powers under the retained EU law Revocation and Reform Act 2023 in specified circumstances to refer a question on a point of retained EU law to the courts or to participate in proceedings on a question of retained law. So it's for EU retained law. It's a retained EU law, difficult to get that right. So it's hard to know how often those issues are going to arise in practice at the moment, but they are there. I have also been given a very recent new power to act under Regulation 5 of the Windsor Framework Implementation, Regulation 2024. So that allows me to take or defend High Court proceedings when a question arises about whether a function of a Northern Ireland department is exercised for the purpose of observing or implementing what is called a relevant provision of the Windsor Framework. So again, I don't know if that will ever arise in practice or not, but it may. Very importantly, I also have functions under the Mental Capacity Act Northern Ireland 2016, and this is a very important area of work, and it takes up a very large part of our office resource and staffing. I know that the previous attorney addressed the previous Justice Committee about this just as he was about to step down in June 2020, because this the relevant provisions of the 2016 Act came into effect at the end of 2019, so they're fairly new then, and there would have been a small number of cases per day. But the number of cases has ramped up to approximately 25 cases a day, and on occasions we may receive up to 54 authorisations to be reviewed in a single day. So I have a small team of paralegals headed up by a lawyer who look at those authorisations initially, and then they come to me. So the review tribunal, which is formerly known as the Mental Health Review Tribunal, is an independent judicial body, so that will be of interest to you, and I'm sure that you will be engaging with the court service in relation to a number of functions. So just to explain what it does, it has functions as regards those who are detained under the mental health legislation, and those whose care arrangements has to be such that an authorisation depriving them of their liberty is required. So that is a fairly extreme thing to do, and there needs to be judicial superintendence of that. That might be because a person has dementia or a severe learning disability or for other reasons. So my role is to review those authorisations and to refer them, if necessary, to the review tribunal. So the important thing there is to ensure compliance with Article 5 of the Convention, the right to liberty, and to secure a person's right to review by a judicial body, because they don't have the capacity to make that decision for themselves. So I would point out that very few provisions of the 2016 Act have been commenced to date. So there will be, if further provisions are commenced, there will probably be a further workload coming to my office in relation to that. But it is a very important role, and I think it's one that people don't know very much about. It's a very complex set of statutory provisions, and we do need to have expertise in Northern Ireland in that area. And because the legislation is, while not new, has only recently come into operation, the courts may ask for my assistance, and the tribunal does, with certain very complex questions of statutory interpretation. So that's quite precedent setting, as you can imagine. And I'll end by talking about my general engagement across the justice system, which is fairly wide. As you can imagine, I engage a lot with the Attorney General for England and Wales, who is also the Advocate General. We don't have a separate one for Northern Ireland, unlike Scotland. And I engage with the Judiciary, the Lady Chief Justice, the DPP, Departmental Solicitor, and I can say a bit more about that relationship, Office of the Legislative Council, of course, the Bar, the Law Society, and a range of other legal colleagues who are connected to the justice system. So it's very important to maintain those relationships and to just keep your antennae tuned as to what issues might be arising and to support those bodies in their aims. And I also engage with the Attorney General in Dublin occasionally when needed, and the Counsel General in Wales, and on occasion Commonwealth colleagues as well. I had a Commonwealth role where I met all of the Attorneys General of the Commonwealth, all 52 or 53 of them, and it was very interesting seeing the different roles of Attorney General. I wish that I had thought of doing a PhD in the subject before Dr. Conor McCormick produced his from Queen's, and it's interesting to read that book about the issues facing. I'm also consulted about a number of important appointments in the justice field, so those include the appointment of the Crown Solicitor and the chair and members of the Law Commission, and that may interest you. And there are also a number of statutory obligations placed on criminal justice organisations to consult with me. For example, the Chief Inspector of Criminal Justice, who I'm sure you will have present to you as well, and indeed the Department of Justice before a programme of law reform is approved by the Law Commission when we get that body up and running again. So as you can see from all of that, the role of the Attorney General for Northern Ireland is a much wider one than most people would know of, and I really am passionate about increasing awareness of it, and happy to come back to you to talk about that at any time. And thank you again for your interest. I'm very happy to take any questions, and with my team or myself.
Thank you very much, Brenda, for that. That's a very comprehensive overview. I have Deirdre first. Anybody else?
Yeah, no, thanks very much, Brenda, and your team for coming in today. And as you say, you cover a wide range of stuff, and probably important areas that people don't even realise, or there's not as much scrutiny or kind of insight into. But some of the stuff I just had was around, I suppose, in terms of compatibility then with human rights and balancing rights, as you say, and then also your role in general litigation matters in terms of public interest. So it's just, what is the threshold of public interest and how is that measured? And around some of these matters, is it each Attorney General's interpretation, or again, is there a standard that's set within the office? So just a wee bit around that. The other question quick was on the inquest stuff, because it is a concern around obviously the Legacy Act now and the impact that that's going to have on inquests. I know you say you cover beyond legacy inquests, but at this point, how many will fall come May in terms of requests that are in the system around the legacy, if you have numbers? And the last wee one again was just around the reviews you touched on in terms of reviewing the sets of guidance for human rights, because you say there are big issues that you deal with around mental health and capacity, other issues that may be around parentage and stuff, and these are big, massive issues that have an impact on individuals' rights out in society and have broader societal consequences. So I was keen to see how you see an increase around mental health and capacity issues, because we're obviously seeing that reflected in the justice system and health. And the other bit around just the guidance, when are you going to review? Is there a timeline for that? And just to ask quickly, do you engage externally? I know you talked about the justice family, but like the rapporteurs, for example, in terms of international human rights, or indeed human rights organisations here locally? And also, does that take into consideration outcomes of cases or appeals through our own domestic courts or European court as well?
Just
in terms of updating.
Dame Brenda.
Questions. Sorry. Well, very interesting questions.
Or you can answer some and then come back afterwards. It doesn't need to be.
First of all, in relation to compatibility, I spend a lot of time assessing both bills and ministers' actions for compatibility, and as you know, the law relating to human rights is less precise in our domestic law a lot of the time, so that takes up a lot of my time. There is also a lot of work that goes on that is not visible, because I think the most effective way of influencing those who make the law is letting them know at the earliest possible opportunity where there may be risks. So I have always wanted to get in at the very early stages, and that's why engagement is so important, to say, I'm in room 227, knock on the door and come in. I'm here every Monday and Tuesday. I'm in the town the rest of the week, but, you know, just come and see me. But it really is a very rigorous assessment, and it is a balancing exercise, like is the case with litigation indeed on these issues. And you've asked about public interest and when the attorney might get engaged, and does that vary from attorney to attorney? And first of all, in terms of public interest, I would look to see whether the issues have been addressed fully, whether there's anything I can add. Sometimes the courts also ask me proactively to provide an opinion, and I think that's very welcome that they do that. I would say also that you've asked whether that depends from attorney to attorney, and that probably depends on how an attorney approaches all of their functions. As I've said, I try to see things off before they arise, and that requires quite a lot of engagement, and that would be how I would approach things. And there is an opportunity in making submissions to the court to draw attention to things that might not have been considered previously, and some of those issues might be in relation to even something which seems as simple as access to the law, but is very important, because if you don't have access to the law, the whole rule of law is undermined. In relation to inquest, you have asked about how many will fall, as you said. In relation to the inquests that I have under consideration, I have only 5 on which I have yet to take a decision. That will be done within the next few days. So I will have completed all of my work on those, and I've taken the view, which is the only right one to me, that my functions continue right up to the end of April. What the courts can or can't do after that is a matter for the courts, but I have been exercising my functions right up to that, even though some of those applications have only come in very recently. But my workload will be complete within the next week or two on that. The fourth thing was relating to the review of the sets of guidance. That's something that we would like to do. We don't have much resource to do it at the moment, and maybe Maura, would you like to say something about that? So we don't have a timeline at the minute.
Yeah, it's really, I suppose, just a matter of trying to keep under review what the big issues are that are emerging. So you mentioned mental health, so we would be thinking about, is the guidance adequate? Does it reflect the current international standards? If there had been a new decision or a recommendation from a rapporteur, for example, we would look at that, see whether there was any need to change, because the guidance at present is quite high level to accommodate a bit of flexibility. And there's a process involved, obviously going through the Assembly, making an SR to change it, so we wouldn't necessarily amend for a word or two. We would just want to make sure there was enough there to allow, or to make it worthwhile to actually issue fresh guidance. But there could be standalone new guidance as well, so that's something that certainly the attorney is considering.
Thank you. Okay, that's good. Thank you, Morris.
Thank you very much, Chair. Thank you very much for your presentation. Indeed, you have a very wide-ranging workload on the area of responsibilities. But you touched upon your role of the appointment of the DPP, and you also alluded to inquiries that people may throw at you about lenient sentences and areas of not taking prosecutions which are not your remit. But do you think, I'm going to ask you a leading question here, if you don't answer that's all right, do you think it's time for a review of the whole Department of Prosecutions? Don't answer if you don't want to.
Well, I think that really is a policy question for ministers. there may be, as a side issue, time to review. You can always review the relationship between the DPP and the Attorney General and the various bodies involved, but again, that's a policy decision. I know the previous attorney had views on that, and so again, that's a matter for ministers, and it's not a very long time since we had criminal justice matters devolved. When you think of it, to me it seems like a long time ago, but it's really not that long. So something that you can propose as politicians, but beyond my pay grade, I'm afraid, at the moment.
Very political answer, thank you very much. And I'm amazed at the amount of work you actually have responsibility over. I need to replay this when I go home just to get it all. But thank you.
Well, not at all, as I say, just come and have a chat at any time. I'm very open to people finding out more about the office.
Thank you. You, Chair.
Stuart?
Yes, again, like Morris, an absolutely incredible breadth of area of responsibility, and one which I have to confess, having been a previous member of this committee, not in the immediate past mandate, previous Attorney Generals haven't managed to explain it in the very friendly way in which you've done that for us today. That's been extremely helpful and a really good overview, so thank you very much for that. Two very brief questions. One, I'm just interested in why the courts would need protection from vexatious complainants from you, and can they just not simply protect themselves? Surely, for example, the Lady Chief Justice could intervene where a judge or others are getting continual litigation from an individual. The other question is perhaps a little on the lines of Morris's one, but hopefully not I understand there's a political question here, but I think there's also a practical question here, and that would be the potential implications of the United Kingdom withdrawing from the European Court of Human Rights.
Well, the first one is the easier one, I have to say, in relation to vexatious litigants, because really the big picture here is that I'm supporting the courts to be able to do their business. And I suppose I can't give you an example of a particular vexatious litigant for obvious reasons, but really there is only intervention when things get extreme. And I'm going to ask Ian here to say something. Ian has had many years of dealing with vexatious litigants, and I don't very often have to step in, but the aim of that is really to support the courts when they have someone off the heft of the Attorney General making an application.
Indeed, thank you, Attorney. It goes back really to a statutory power under Section 32 of the Judicature Act, which gives the Attorney the power to make these applications to the High Courts. It's really a structural thing which is built into the system for the Attorney General, both here and in other jurisdictions such as England and Wales, to perform a very similar role. And in fact, a lot of our case law is taken from the courts across the water. And there's been several cases through the High Court here and as far as the Court of Appeal during my tenure as Solicitor to the Attorney General, which you can find in the law books. You'll see examples of particular situations and why the Attorney is understandably unable to talk about current cases. You'll find in the law reports, if you have access to those previous cases, where particularly the Attorney's predecessor had referred cases to the High Court, and there are several more which are under consideration at the moment. And there's a whole system there, and which ends up in publication in the Belfast Gazette, that esteemed organ, where there's a notice put up saying a particular person is that. So at least readers or people with access to that publication will know where they stand.
Thank you.
And your second question in relation to the ECHR, well, that obviously I've looked at in great detail when there are proposals to repeal the Human Rights Act. So I can't go into detail on that at the moment, but just to say that obviously the major implications for us here in Northern Ireland will be the preservation of any rights which are there as a result of the Belfast Good Friday Agreement and are enshrined in the Northern Ireland Act 1998, a bit like the issues relating to Brexit. So, but there's a lot of work and complication there, and no doubt years of working things out through the courts if any decision was taken politically to do that.
Thank you, Chair.
Members, I'm conscious of time, so because we've got another directorate outside. I've got Justin and then Ciara. Justin? Justin is frozen. I'll take Ciara in the interim. Go ahead, Ciara.
Hey, thank you. I'm just conscious of time, so I very much appreciate you coming along today, and as a new member, I'm delighted to meet you face to face. Suppose one question is, Dame Brenda, are you remaining to the end of the mandate? First, is that?
Well, that's a good question, because the terms of appointment of the Attorney General are set out in the Justice Act, and you can appoint an Attorney General for a period of up to 5 years. So my term will end at the end of June next year, which isn't all that far away, and I can't believe how quickly time has gone in. But First Minister and Deputy First Minister can also appoint someone for a shorter period of time as well, so people aren't very aware of that. So that is when my term will expire. So it has been, we've had a couple of years of COVID, a couple of years of Brexit. I can't think of a more turbulent time, but as someone said before, I really do enjoy a good crisis and getting stuck into it. So it is a term of up to 5 years, and you can be reappointed for any period of up to 5 years after that, but it's all set out in the Justice Act. And there is, interestingly, no provision for a deputy for the Attorney General, which you do have in most of the other offices. So there's a slight risk there. If I get run over by a bus or anything like that, there's nothing else. And the First Minister, Deputy First Minister can make arrangements, but it's just not quite as straightforward as elsewhere.
And just secondly, you had mentioned earlier on about the size of the team. It's quite a small team. What is the size of the team? And then obviously with regards to mental health, and we've heard across obviously justice and increasing that, and we see the outcome of that within our health sector and in our communities. You'd mentioned that. In relation to all the other areas of work, which I wasn't aware of the scale and the breadth, in the likes of the parentage, in relation to missing persons, divorce dissolutions, what's kind of been the trend or increase versus the scale and size of the organisation, and how do you cope, and how is that managed?
Well, that's an interesting question, because I'm trying to expand a bit at the moment. I have 17 staff in place, and that includes my administrative team and my mental capacity unit within the office. So a good proportion of the staffing in the office goes to that at the moment, and we didn't get any extra legal resource for that at the time that was set up, but that was because it wasn't anticipated just how large that task would be. So for a lot of the, another thing is that a lot of the people who have joined the office have become judges. So that's very impressive, and it's very good for their careers, but it's difficult to replace people. So for a lot of the time, essentially, I had the 3 people that you see here who are exceptionally good, and I certainly couldn't do my job without them. They have years of experience, and it's just, I think recruiting the right people is really very, very important. So I have really 14 full-time equivalent permanent posts and 5.8 lawyers. We have some people who are part-time. We have a trainee solicitor, and I have to say they contribute greatly, and it's lovely to see the students coming in and just beginning on their legal career, and 3 paralegals 3.4 administrative staff, and 2 temporary staff at the moment. I don't know how long I'll have them for, but it really is a very small unit, and the hours are long, but everybody is very passionate about the work, which is I think what makes the difference, and everybody's very keen to be appointed to the Attorney General's office because the work is so interesting and varied.
Just regarding the capacity and the increase, you had mentioned obviously it basically doubled a day in regards to the mental health. Is there any other areas that you would have concerns about regarding increase over the past few years that has an impact on level of work required?
Well, probably in relation to some of the areas like the production of human rights guidance, we could do with a bit more resource in that respect, and it would be, I think, a good idea to have a formal director or chief executive officer, I think, because of the nature of the role, because very often you will have somebody, and the previous attorney referred to this in the setting up of the office, who will be coming in directly from the bar. I was about to say I'm kind of unusual because I have been a civil service servant and a diplomat and done a range of other things, but the Attorney General for England and Wales spent 17 years in the government legal department, so like me, she has that experience, but you may be coming from the bar as a very experienced senior counsel, but the machinery of government here in Northern Ireland is so complex, you need a very, very good team, and I found that extremely helpful when I came in, even though I had very much of the background from the 1998 onwards and involved with the political negotiations. That Ian had such experience in relation to litigation and more in relation to human rights issues, and I'm very lucky that Orla has joined us for the past year, and I have her on a temporary basis at least. I'm delighted to have her because she's really focusing on EU exit matters, which is just one of the most complex areas of law you could ever imagine to deal with. So we're a very tight team and work well together, which is important.
Thank you. Thank you.
Thank you. Members, I'm just conscious that we are already 30 minutes over time. Justin, we'll try again.
No. Frozen again.
Justin?
Challenging remit. In relation to, yes, Chair, can you hear me?
Yes, yes.
Hello?
Yes, we've got you. If you might be helpful,
Brenda,
just turn
you
your
have a
screen.
challenging and broad remit.
Justin, if you turn your screen off, that might help.
Okay. In relation to Mental Capacity Act, the Attorney General currently deals with approximately 25 deprivation of liberty authorisations a day. On a 48-week year, that amounts to 6,000, 5-day week, that amounts to 6,000 a year. How on earth do you accommodate all that burden, and how does the system accommodate that burden of cases?
Well, that is a very good question, because it doesn't just have an impact on my office, but obviously the trusts, the doctors, the nurses, the social workers, and indeed the tribunal, particularly from your point of view. You'll be interested in that because there's had to be a huge increase in the number of members appointed to those tribunals, and I have exact numbers here, if you can just bear with me for a moment. I did bring those along today of the numbers. 20,000 cases in the last 4 years. So that's a very large number of cases going through the system. And it is very time and resource intensive because there are over 20 forms, which importantly have to be assessed, first of all, because if there's an irregularity in the forms, that may affect the legality of the detention of the person. So I think the fact that my team deals with so many per day is a real tribute to them, and I'm very proud of them in doing that. but it was unimaginable. And starting off at the beginning of my appointment, there might have been 4 or 5 a day. And as I say, that has really ramped up with a big impact on every part of the system.
Hey, Justin?
I think he's gone.
Yeah, a shocking statistic. 20,000 in the last 4 years, just extraordinary. And my heart goes out to all those people impacted and to the teams who are dealing with them. In relation to the 1st of May troubles related inquest, Cliff Edge, there are those who are waiting with bated breath. Families of the victims who are seeking a charge before that deadline, and perpetrators who are just waiting to know that after that Cliff Edge, they're off scot-free. They can live their lives now without concern of being tackled about their deeds. What was your advice to the executive on that bill?
I'm not sure the Attorney General can give that information, Justin. I think that advice to the executive from the Attorney will be privileged, as any legal advice is. Is that fair enough?
That's correct, Chair. So, and it is really an act of the UK government, and I know that the different political parties have voiced their own views on what they feel about the Act. The other thing is that aspects of it are of course being litigated at the moment, and we can't comment on that. But I understand that the cases are being expedited, so we may hear more before long.
Okay, members, on that basis, we're now kind of 35 minutes behind with 2 more evidence sessions to come. Could I thank you, Dame Brenda, Ian, Orla, Maura, thank you so much for taking the time. It's been really useful to understand the breadth and depth of your work. No doubt we'll be dealing with you in future going forward, but thank you very much for today.
Thank you very much. I wish you all very well.
Members, just while we're waiting for the Safer Communities Directorate to come in for agenda item 6, I would ask you to turn to pages 55 to 67 of your meeting pack for the relevant papers. So again, the Safer Communities Directorate are going to provide an overview of the work that they do. They're scheduled for 45 minutes. And we have another session after that. So please, if people have things that are, absolutely necessary, ask it. Absolutely tease it out. But if there's things that can be resolved in writing or through written questions and so on, please do that. And that'll try and help us get through with and prioritise the issues that we need to raise with the Directorate. So everybody, thank you very much. I apologise that we have kept you waiting for that length of time. That's unusual, but you'll appreciate we had some other issues to work through, so I apologise for our tardiness in that regard. So with us we have Mark Goodfellow, who is the Director of Safer Communities, Lynn Curran, who's the Head of Policing Strategy and Engagement, Katie Taylor, Head of Protection and Organised Crime Division, Michael McAvoy, Head of Community Safety Division, and Graham Walker, Head of International Criminal Justice Cooperation Unit. And by the time we get through that, that's another 5 minutes away. Thank you very much. Folks, well, the intention here is to hand over to you. You can give us your briefing, and then we'll move into questions. I have asked members to avoid commentary, straight to questions, and to prioritise so that we try and make up some time, and I do apologise for keeping you. Thank you.
No problem. Thank you very much, Chair, and it's great to be here. Great to be back in room 30 and full use again. So thank you for the opportunity to brief the committee. Appreciate very much the pressures on your time, and I think from our perspective we would be really keen that today would be the start of a process of engagement rather than a single event. So thank you. I will dispense with the introductions, Chair, because you've helpfully done that for me. So I'll move on to the main briefing. And I'm conscious that we've sent you a very short briefing paper, so over the next few minutes I would just hope to set some context and add some colour to that for members. So in terms of the remit, the structure, the size of Safer Communities Directorate, our responsibility extends to the resourcing, the policy and the legislative framework for policing and community safety right across Northern Ireland. I also lead on security related issues across the executive, and in terms of staff size we have about 300 staff in the Directorate, and that's across the 3 divisions that are represented with me today, but also an executive agency, Forensic Science, NI, on which we would be very happy to arrange a separate briefing for the committee. We also are responsible for the governance and the sponsorship of state pathology and a range of arm's length bodies across the justice sector. And we also host, for administrative purposes, the executive programme for tackling paramilitarism and organised crime, on which I understand you have a separate briefing scheduled. In terms of money, my directorate has a resource budget of around 20 million, but a programme budget of more than 800 million when we add in all of the ALBs into the mix. And specifically on budgets, I'm conscious you've already heard from the Permanent Secretary and other Director colleagues on the challenges of continuing to deliver for the justice sector. So I don't intend to repeat too many of those messages. Suffice to say that of the pressures going into next year for DOJ that are sitting just under £500 million, 374 million of that sits within my directorate, and the vast majority of that then sits within the PSNI, as you might expect. We are a demand-led service, so that severely limits our ability to generate savings and easements. And to illustrate this, obviously I cannot control the demands on police time and the requisite resourcing demands that we'll place upon it, any more than I can control the number of victims of modern slavery and human trafficking. So very much a demand-led directorate in that sense. At a community level, in terms of how else could I potentially save money? Well, in theory, I could stop things like funding probation board to deliver enhanced combination orders, ECOs, but for me that clearly is a false economy because it wouldn't generate savings. All it would do would be to displace costs to other parts of the justice system and add to short-term prison sentences. And I know you've heard from the Director General of the Prison Service around the pressures on the system there as well. Likewise, within our directorate, we're responsible for electronic monitoring. So in theory, I could stop the contract for the provision of electronic monitoring, but then we're starting to reduce the public protection arrangements and confidence therein, and again, removing a tool from the judiciary, and we would just simply displace the costs and the pressures because other parts of the system would need to pick that up. So from my perspective, there are a lot of things across this directorate that we simply cannot afford not to do. So the written briefing that we provided in advance sets out the overview for the divisions represented here today. So we won't go through that today, but I thought it would be worthwhile just drawing out the span of control and responsibility that we have across the directorate, because we carry an absolutely fascinating and a privileged mix of roles, and that covers sponsorship, legislation, operational delivery, and a lot of public-facing roles as well. I've previously used the phrase, as have senior PSNI colleagues, that policing is way too important to leave it to the police. And I don't mean by that to be critical in any sense of the police, but what I do mean is that every aspect of society has a clear responsibility to support the PSNI to keep communities safe. And exactly the same principle applies across this directorate. I can't keep communities safe, my colleagues can't keep communities safe without working collaboratively within, across and beyond the justice system. So that collaboration is absolutely critical for us in order to build those safer and more resilient communities. And quite often, as members will be aware, those who come into contact with the justice system do so because of socio-economic challenges upstream, whether that's health inequalities, whether that's educational underachievement, mental health, relationship breakdown, housing. So all of those issues are socio-economic. They're not justice issues, but they very quickly manifest themselves as justice issues, as you will be aware. So in terms of crime, antisocial behaviour and fear of crime, that's where we need to focus our efforts. And another example where we don't hold ultimate responsibility, but we do lean in quite heavily because it will become a justice issue, is that around contentious bonfires. We're coming towards that time of the year again. So from a DOJ perspective, we're not a landowner, nor are we responsible for the issue. But at the point where community tensions start to rise and that escalates into antisocial behaviour and or public disorder, then it quickly becomes a justice issue. So we're very clear that we're part of a group and we play our part with the Memorandum of Understanding with other departments to try and get ahead of that issue upstream and to try and mitigate the risks around issues like that. The good news, bearing in mind that our title is Safer Communities Directorate, is that in Northern Ireland, we are, in relative terms, a very, very safe place to live, to work and to socialise. So recorded crime in Northern Ireland, significantly below that in England and Wales. The latest figures are that we have 56 recorded crimes per 1,000 of population, relative to 94 in England and Wales. And that's not to be complacent in any shape, sense or form. One crime clearly is a crime too many, but in relative terms, we are a very safe place to live, to work and to socialise. And of course, you'll be aware of the recent reduction in the threat level from severe to substantial, which is also very welcome news. So from my perspective, I'm very proud of the multi-agency approach that this directorate takes across our span of remit, whether that's planning for parading and bonfires with TEO, with DFI, with DFC, with police, with Education Authority and others, whether that's working ever closer with Department of Health on that health and justice interface, which is an area I think we need to get even better at, around mental health and the prevalence of mental health in the criminal justice system, and whether that's working collectively with DOH on implementing coroner's inquest reports. We also work collaboratively, as colleagues will be aware, with PCSPs, and that includes independent members, elected members, and a range of designated organisations. So collaboration and multi-agency working is at the heart of everything that we do. Some of the other sectors that we work with include women's aid, includes migrant help, and includes health and social care trusts, as we support victims of trafficking and exploitation, and also with the Home Office and with the Security Industry Authority on some licensing arrangements for security personnel, and importantly with voluntary groups such as the search and rescue groups who give up their own time in the pursuit of helping others. So our attempts are to try and divert people away from crime upstream when we can, but we're realistic enough to recognise that that is not always possible. So we're also responsible for managing the public protection arrangements across Northern Ireland, working closely with operational partners to manage offenders in the community, and when they fail to adhere to their conditions, to recall them to custody in the pursuit of keeping people safe. So this directorate plays a critical role in working collaboratively across Northern Ireland to build safer, resilient communities. But we have also established a footprint on a cross-border and a wider international basis on areas like community safety structures, on forensic science, on organised crime and cross-border policing. The Northern Ireland justice system continues to attract an awful lot of interest from EU and beyond. And we completed with the mandate from the Minister before she left office last time around a series of engagements in Brussels and Washington, just mapping out that social model of justice, the evolution of justice since devolution, and the evolution of the community policing model. But we did that not in a splendid isolation. We did that with our colleagues in the PSNI. We did it with Youth Justice Agency. We did it with Probation Board and colleagues from the Executive Programme on tackling paramilitarism and organised crime. And whilst we've always enjoyed really strong relationships with the UK and the Irish permanent representation in Brussels, that programme of visits has generated quite a significant number of inward international visits. So we get a lot of visitors coming in now from justice systems across and beyond the EU, wanting to learn from good practice here. So I think we have a confident system now where we no longer hide behind the curtains and look for best practice elsewhere. We're absolutely open to that, but quite often when we do travel and visit looking for good practice elsewhere, we come away with an affirmation that actually where we are in the justice system is in a fairly good place. So that affirmation is incredibly important as well. And Chair, I'm conscious I'm now in danger of straying beyond my commitment to keep my opening comments brief, so I think I'll stop there, conscious of your time constraints. I'm very happy, obviously, to take questions.
Thank you very much. Usually I don't go first, but in this circumstance I am, because I didn't ask the Attorney General any questions, so I'm sure members will indulge me in this case. My first question I think you can answer in writing. On page 60, it's your briefing around protection, organised crime and current key issues. On your last bullet there, you make reference to an addendum work plan to the organised crime strategy being prepared for 2024-25 alongside consideration of the strategic approach to organised crime for the next iteration. If you could, and I'm happy to take this in writing, you don't need to answer it now, I would be grateful to understand when you think that's going to be ready, and also to what extent that strategy has informed the proposed legislation that's coming forward with regard to organised crime that the Minister's looking at for our next bill. So if you could respond to me about that in writing. Sure. It's our page 63, I'm not sure what it is for you, but it's with regard to community and safety, policing and community safety partnerships. You'll be aware of my previous tenure in the policing board, and I am not always sure that we get the bang for our buck from PCSPs as much as to the extent that we might. And I appreciate that there's a tripartite arrangement, and I am clear of the boundaries within the policing board, but it would be useful to have some understanding as to whether or not there are conversations ongoing as to what could be done to help improve, review PCSPs, just to make sure that everything is as it should be and we are maximising the potential of those bodies. That's that one. The next one is the next page, which is you refer to challenges around MARA, which is multi-agency risk arrangements, and public protection arrangements in Northern Ireland, and managing the risks posed by the most serious and sexual and violent offenders. It would be helpful for us to have some understanding as to what the challenges are around that. And finally, is page 66 of our papers with regard to human trafficking and the national referral mechanism. I am concerned. I appreciate that you have said there that the figures are significant and they're in the 400s and 500s and so on. But with regard to this, and indeed child sexual exploitation, on questions to the Chief Constable and from other research, it has become apparent to me that we are merely scratching the surface. And while those numbers seem significant, they are not significant when compared with the people who are actually at risk and in the throes of being trafficked and are being used for slavery and sexual exploitation. So what is being done to try and get us to a position where our figures are more accurate, that more people who are at risk are being identified? And I suppose the other issue is what is being done to ensure that society at large recognises the signs and can report, because at times when I've had constituents come to me with reports of what they consider to be questionable activity in homes in their area, which may be people paying for sex and so on, and exploitation of women and young girls, that it's very difficult to have action taken. Now that's a question for the PSNI, but the issue is the education of people and building confidence in people to report and have those issues taken seriously, because to my mind, anybody who is trafficked and who's being exploited in that way, those people are not living, they are existing, and we have an obligation to do as much as we can. So those are my questions. Thank you.
No, thank you, on very good questions. I mean, on the first one, PCSPs and bang for buck, yeah, look, absolutely take the point, and I think we would view from within the department a spectrum of performance across PCSPs. So some we're probably seeing more explicit bang for buck than for others. I mean, I would say that actually there's an awful lot of sort of unseen, and it goes back to your last point around awareness of modern slavery and human trafficking. There's probably a job of work for us to do as well, Chair, in terms of are we maximising the awareness of PCSPs and the role that they can play in supporting local communities. So some of the stuff that that they've done around community safety wardens, which is critically important in areas like Derry and Londonderry, linking with other agencies. Work around multi-agency support hubs, which is starting to identify the most vulnerable people. So a lot of that is critical. Not everyone would necessarily align that with the work of PCSPs, but I think we will have an opportunity, given the most recent Sagini report, which recommended the development of a new community safety strategy, and as a key local delivery mechanism, the role and the bang for buck and the value for money that we're getting from PCSPs would have to be absolutely part of our consideration around that. So just an assurance that we absolutely will wrap up that point in the development of a community safety strategy. And on your second point, Joanna, around Mara and some of the challenges, and the committee will be aware of the sort of the huge complexity and sensitivity around some of these areas. And in anticipation this would come up, we were going to suggest that actually it might be helpful to have a separate closed session on Mara, so that we can get into the detail of some of that, if the committee would find that helpful.
Members be agreeable to that?
Yeah.
That'll be lovely. Well, then we'll hold my question until we receive that briefing. Thanks, Mark, and that'll save us a bit more time.
We're
That's
happy to
great.
do that. On modern slavery and human trafficking, I mean, completely agree with you. You know, heinous crime. We want to be clear. We want to be able to build the confidence of people to report this. I hope the figures are accurate for now, but as always, it's probably a hugely underreported issue, and we need to do more around this. There is a 3-year strategy that the team has developed. That's gone to the Minister for consideration. We will absolutely come back to the committee and share the detail of that strategy when it's there. A key component of that will be awareness raising, because in some ways it's the same principle as many years ago trying to raise awareness around issues like domestic and sexual violence. You've got to raise awareness to build the confidence within the communities to report, but also be ready to develop a really good strategic comms piece around that, because when that confidence is there, your reports and the numbers are going to go up, and that's either going to be seen as a really, really bad news story or the start of a good news story, because the confidence is there. So we're acutely aware of the need to raise awareness of that. And to bring potential victims in. There are also, you know, clear differences between the numbers of people identified and the relative percentages in Northern Ireland versus the UK. So, for example, 4% of the victims of slavery and human trafficking in Northern Ireland have been trafficked within the UK. Compare that to the wider UK on a holistic basis, and 49% are trafficked within the UK. So we also need to understand, why is that disparity? Now, there's probably something around county lines, and we have one police service and there are multiple constabularies, but there are many areas we want to get our heads around. But awareness will form a key part of the modern slavery and human trafficking strategy, alongside the 3 themes of prevent, pursue and protect. But Graham, is there anything you want to add specifically around that awareness and confidence raising piece?
I suppose, yes. Thank you, Chair. As Mark says, the training and awareness piece will form a large part of our 3-year strategy, form part of that action plan. Training has continued over 2022 and 23 across a range of sectors, including PCSPs and Prison Service Compensation Agency and with DFC. One of our NGO partners has also developed tailored e-learning training, which have been made available and look at sort of how to identify and to report. We've of course had Anti-Slavery Week at October of last year, so there was quite a bit of awareness around that. I think on your point around the NRM, we need to understand why the number of persons being referred into the NRM in Northern Ireland is so low in terms of local individuals, and certainly the disparity in the numbers of persons in the UK. So UK nationals or local nationals within GB being referred in is much higher than in Northern Ireland. So there needs to be a piece of research, I think, commissioned around that. Again, that would form part of our action plan. There have been a number of recommendations, including by Sejini, around trying to understand that dynamic. So that is something certainly in our forward plan.
I'm really glad to hear that you're alive to that, because that legislation at the time was groundbreaking, and I have never felt that we have implemented it the way it might have been to the benefit of people who are being trafficked and enslaved. And the people who need help, and I've never been clear that we've been able to reach them. So it's really helpful to hear that is on your radar, and thank you, and no doubt we'll continue to follow that with interest. And I've no doubt your figures are accurate. The issue is the people that we're not able to reach, who find themselves in the circumstance. And I'm aware, obviously, that the NCA has done some good work and some good campaigns around this too. So thank you very much. I'm going to open it now to Morris.
Thank you very much, Chair. Thanks very much for your presentation. I know you have established some fantastic relationships internationally and across border, and long may it continue. But my question's around the organised crime piece. How much of organised crime in Northern Ireland at the minute is still orchestrated and organised by paramilitaries, and how much of the organised crime is gathering apace by non-paramilitary organisations, economic crime gangs? And do you foresee in the future an outbreak of violence between both groups in relationship to who controls what? Not just in this country, but in the Republic and the UK. And look, we all know it. It's Europe-wide now, if not worldwide.
Yeah, thanks, Morris. Yeah, I mean, organised crime, there's no doubt in my mind there is a blurring of lines increasingly between organised crime and paramilitarism. I think we see that. Organised Crime Task Force obviously is there and is pursuing people, individuals, organisations. We also have plans for more legislation because on organised crime, as you'll be aware, actually there is no legislation at the moment that can convict someone of directing or being a member of organised crime. So you actually have to get them on a drugs charge or another point. So I think that will absolutely strengthen our hand here. On the cross-border piece, you're right, we do have really, really strong relations, both at a policy level between ourselves and justice colleagues in Dublin, but probably more importantly even at an operational level. So I think the relationships between PSNI and Garda Síochána have been particularly important, and we've seen those bear fruit in recent times. But Katie, anything you want to pick up specifically on OC and the linkages?
Yeah, I mean, I suppose to to specifically answer your question, it's something we'd need to engage PSNI colleagues to get a more detailed operational understanding of whether they would be able to break down the figures in terms of what percentage of organised crime gangs that they deal with would have a paramilitary element. But just to reiterate what Mark has said in terms of how that works, in terms of the structures working together, we obviously have the Joint Agency Task Force, which works on a cross-border basis specifically to look at issues around organised crime and other crimes that have a cross-border basis. We have the Paramilitary Crime Task Force, which, as you all know, was set up under the Fresh Start arrangements to look specifically at paramilitary-related crime. And then we have the Organised Crime Task Force, which is a strategic structure which brings together operational and strategic and public sector partners to make sure that we are making those linkages. So the work isn't done in isolation. So the work around sort of localised organised crime and paramilitary crime isn't done in isolation. There are strong linkages across the two. I think certainly something we've alluded to in Chair, to go back to, I suppose, your original question and the correspondence that we received from the committee a week or so ago. It's something that we want to explore in the next iteration of the organised crime strategy, is just ensuring that those linkages are as strong as possible, because we're very conscious of the fact that you can't draw a very neat box around sort of organised crime and paramilitary activity. The two issues are very much have a crossover. So that's something we want to just make sure it's there at the moment. Partners all talk to each other, they're all working together, but we just want to really emphasise that and make sure that in terms of our strategic framework going forward, we are making that as robust as possible.
Thank you very much, Chair. Just one other question with the PCSPs, but you have more or less stole my thunder. Thank you, Chair.
Thank you very much. Stuart.
Thank you, Chair. And again, thank you for all the areas and topics that you've covered with us. You made reference to bonfires and the fact that we're starting to move into that season now with the collecting of materials for bonfires. While you're obviously not a landowner, what advice and guidance are you giving to those public sector bodies that are landowners, both in terms of transformation towards safer, more effective sites, but also what action is being taken where public authorities are either failing to or deliberately ignoring those sites which are abused by people who build bonfires on them? And also, what's the public safety implications with regards to that, both in terms to the land, to buildings, and particularly to people who are involved in all of this, because they don't have the approval of the landowner?
No, indeed, and it is it's an awful problem, and as I said at the start, Stuart, you'll know this, you'll be aware. I mean, obviously DOJ doesn't hold, indeed no one holds policy responsibility for bonfires, which perhaps is part of the challenge that we face. But that doesn't absolve us of responsibility, because we need to try and work upstream such that the police don't get drawn in where the resources are scarce anyway. I referenced earlier that we have a memorandum of understanding. Now, those are just 3 words, but in effect what that does mean is that we get together routinely throughout the year, not just in the immediate run-up to the bonfire and parading season. And we have communities, justice, infrastructure, housing executive, PSNI around the table. We run regular horizon scanning sessions with them to try and anticipate where are likely to be the problem sites, and we can name them around this table. Adam Street in recent years has featured up there, Hope Street has been there, and some other sites. But we also work really closely with the Fire and Rescue Service. So in terms of the advice that's going out, Fire and Rescue Service are very proactive about going out, engaging at a community level with the PSNI, focused very much on the protection of life and the protection of property and the inherent risks that come with that. Not environmental risks as well as health and safety risks. So we have that. We have a strategic engagement group which sits at the more senior level with the executive office as well, because obviously we're looking at things like FIC, we're looking at how we contribute to together building united communities. So there's a clear role in there for the executive office as well. And I guess the MOU, it's more than a talking shop, but it is the opportunity to bring together the key partners and the landowners to make sure that everyone understands what the inherent risks are and that every possible action is being taken to do that. So from our perspective, we lean in as much as we possibly can, but we do so whilst recognising the independence of the other organisations around that table.
Just very briefly, is there a recognition that there are effectively what could be described as repeat offenders and public authorities and landowners who just simply are avoiding taking any action?
By exception, that happens, yeah, there's no question about that. So there's a recognition the tools in order to deal with those is slightly more difficult. But Michael, is there anything from your side?
As Mark says, Stuart, problematic bonfires are those that put people, property, the environment at risk. And our focus is genuinely on a very, very small. You've got to acknowledge that a lot of bonfires pass off as a cultural celebration and are enjoyed and don't do any of those 3 things. But the focus of the MOU group is to take a look at the ones that are problematic, and they are a very small subset. We have no powers to direct those landowners. We draw attention to the risks. The Fire and Rescue Service are not there to adjudicate a safe bonfire, because let's be honest, there is no such thing as a safe bonfire. And in the past, whenever they have given advice, sometimes people have come back and said, but sure, we did build it, 5 metres for every 1 metre of height, and we still set fire to 3 houses in the Lower Shankill estate, because you can't really mitigate all of the risks associated with a bonfire when it gets out of control. So no, I mean, Mark mentioned FIC. Genuinely, I believe that's the route to work out a positive way to celebrate culture that involves the use of potentially a bonfire or a version thereof, which is safer and genuinely allows people to enjoy that aspect of cultural celebration.
Thank you, Chair.
A rule for partner communities too, actually, because I think part of the difficulty is people have been designing out cultural space, which leaves us in a situation. Deirdre.
Yeah, I'll start with that last one first, because you touched on it there. So I think it's good that Adam Street's moved on and progressed. So fair play to everybody involved, and particularly the communities on the ground as well, to see a housing-led regeneration scheme there. So I think that's really good, and actually can show what can happen in terms of the engagement. And I think events over the last couple of years has kind of pushed it in that direction. My question's more or less around in terms of where there are still peace barriers and walls and physical barriers and segregation. And as you touched on earlier, that overlaps often in terms of social class and poverty and deprivation and inequality. And what I would say is the invisible barriers of class segregation in our urban settings particularly, I think it's more visible. And it is just around, I suppose, the history of how communities have been redesigned in the 60s and 70s with defensive planning, which actually doesn't serve the communities now in 2024. So it's just what work the department's doing around overcoming the legacy of defensive planning and obviously the impact of conflict, but also trying to work with other departments in terms of addressing social and economic inequalities and trying to raise the aspirations through community wealth building, just how land can be taken forward in terms of the public ownership of land. So just a wee query around some of those issues, and I suppose the good practice from Adam Street in terms of how it's progressing. I'd be keen to hear that. The other bits just quickly on just to really reinforce the tripartite arrangements in terms of yourselves in the department, the policing board and the PSNI. I think that's critical, that those relationships and those arrangements continue. The review of the policing board, you touched on the terms of reference, just keen if we could get access to the terms of reference and the timeline for the review. Is there a timeline set in terms of when that review will be conducted, and before it's approved or whatever, what the process is with the policing board in terms of agreeing or signing off on that? And it just mentioned in your report pack as well, sorry, I think it's on page 61 near the bottom, so just in terms of the Justice Bill work being progressed in terms of organised crime legislation, the terms of reference, and it just says in terms of some of the stuff coming from Westminster. So just is there more detail that can be sent to us around what that's going to involve, and the impact around any potential Westminster legislation that may be coming forward in terms of extending powers that would be available here. So just a wee question on that. And I know you touched on traffic and we may come back to it, but just the impact in terms of housing around Airbnbs and things like that. I'm seeing that just in the community I live in, our city Belfast, where I suppose the lack of oversight with Airbnbs, and how some of those, are you finding that as a more common theme now in terms of trafficking, or not? So just thank you.
Maybe just in terms of time, with regard to the criminal justice bill, we're about to kind of cover some of that in the LCM stuff. Okay. So if you're content, we're going to cover that later on, Mark, because the next set of officials are to deal with that issue.
Yeah, coming in straight after. So, okay, no, that's helpful. I'm going to ask Graham to come back to the trafficking point, but if I cover off the first two, and Michael jump in as well if there's anything in terms of barriers, interfaces, and I guess the strap line that we're using in the department, Deirdre, is that of the 59 remaining structures, the 59 that we inherited, a third have gone, so they've been removed. A third have been reduced. The remaining third is where the focus has to be. But as you know, the work on that absolutely has to be underpinned with the principle of community consent. So it's when the community is ready to move forward with that, and we're continuing to work on that. I think there's been some really good work done recently. I mean, the vast majority of fencing around Derry's walls, for example, is now gone. So, that's been a recent move, and we just want to keep the momentum going on that. The wider socio-economic stuff, I mean, that's, from a justice perspective, we're really, really keen to work more collaboratively with health, with communities, with housing, because it's all of that socio-economic stuff upstream that will influence justice downstream. So really keen to continue to work on that piece. I'm glad you recognise that the tripartite relationships, and you're absolutely right, those are critical and actually have been critical to surviving the last year, frankly. We've had some very significant challenges. Chair, you've been very aware from your previous role. And actually,
I lived there for a while.
The tripartite relationships, I guess, were the glue that kind of held a lot of things together. And that actually tested the tripartite relationships in terms of how do we get through the data breach, how do we get through the resignation of the chief constable, the unexpected absence of the deputy, and everything that flowed from that. There was no process map for that, but actually it was a good test of the tripartite relationships. In terms of the policing board review, which kind of flowed out of everything that happened there, you'll be aware that was commissioned originally by the policing board, or announced originally by the board. When devolution returned, the minister was quite clear that as a department we ought to take ownership of that. Policing board are content with that. In terms of how would we take account of the views of the board, the policing board already had done quite a developed piece of work around terms of reference and areas that they would wish to see included in that review. We have taken that, we're doing some work, we're consulting with some stakeholders, we're meeting with Chief Constable tomorrow, for example, on that. And then the Minister will take a view in terms of reference, but absolutely happy to share those. I mean, in broad terms, in terms of where I would see the terms of reference going, subject to the views of the Minister, there's some themes that we would see being critical in there, and a few of those might be strategic planning, and by that I mean, how does the board support, advocate, direct, and provide direction for the PSNI? Board functionality, the leadership of the board, the appointment process for chair, for me, actually is something that we need to think more carefully about, and the wider governance arrangements. To what degree does the board espouse the highest standards of governance, propriety, and all of that? How do they listen to the community, take account of stakeholder views and reflect that? And do they get the balance right, for example, between holding the PSNI to account and providing that support and advocacy role and outreach role? So those are some of the areas, and actually there's some areas in there for us as well, I would suggest, Deirdre. So how do we as a department hold the board to account in the delivery of their role, in the same way as the board hold the Chief Constable to account? So I think there's some stuff in there for us, and also to have a look at what executive support does the board and board members get. So from the Chief Executive and the team, is that fit for purpose, the composition of the board, the structure of the board? So quite wide ranging and not fixed, but those are the broad themes that I would expect to flow out of terms of reference.
Just on that point, can I declare that at the time of the term of reference kind of agreement and all that, in that piece of work, Morris and I were on the board at that time.
Yeah. I'll declare an interest too.
Just it's better to have that in the record than not, I think.
Okay, Graham, do you want to pick up on the trafficking point specifically?
Yeah, I mean, Airbnbs, to my knowledge, haven't been raised specifically as an issue, but it goes to the point, I think, that we're all agreed. It's the awareness across all sectors is really important. I know that the department has, we've produced a range of leaflets in a range of languages which have been shared with PSNI recently, and that's part of PSNI going out to estate agents and various others in that sector. And again, the comment that I made in response to the chair's question, the work on the ground with PCSPs in the local areas, just to make sure that everyone in local areas is aware of the signs, knows how to report, and is alive to the issues.
Council officers, Royal Mail, teachers, I think.
Yeah, absolutely.
Thank you. Ciara?
Just a quick one, because I'm conscious now of the timing. A lot of the areas are covered, so it's just in relation to the community safety strategy that you hope to move forward with. If you have any timelines and what resources you'd put to that. I'm conscious someone who has worked in the CMV sector over 20 plus years and faced with, whether it's bonfires, antisocial behaviour, etc. It's the neighbourhood and the communities and the resources invested in the local organisations, and that can have such a positive impact, and that's what's happened in the likes of Gaia and in my day when I was there regarding youth educating safely, alternative to bonfires, etc. A range of really innovative good practice that costs very little but could have and as you mentioned, the collaboration is critical in this, and particularly in relation to housing as well and our new housing estates. There's still failure in the design of those estates to design out crime, all that type of stuff. So I'm conscious it's great to see that there is going to be, but you had mentioned here in your report about depending on resources, how important is it, and what's your thoughts on taking it forward and how soon that could be taken forward?
Okay, thanks, Ciara. The recommendation made by Jenny was that we should come back with a strategy and an action plan within 1 year. So that I have to say is going to be a really, really challenging time frame. And I say that not because we lack ambition, but quite the reverse, because I'm old enough to have been the owner of developing the first community safety strategy back in 2012. And actually that probably took a good 18 months with a dedicated project team. And it took that because we took it seriously, and we want to take this one seriously. So for me, the development of a community safety strategy, you know, a few of us could sit in a darkened room and write it from within DOJ. That's not going to land, because actually a community, whilst we need to own it as a Department of Justice, it needs to be a community safety strategy that everybody across Northern Ireland can buy into. So that brings us straight into that collaboration with health, with communities, and with education and with other departments, because it is those people who are failed by other socio-economic challenges that will find their way into the justice system. So we need to find a way to get our socio-economic departments on the hook, which is why we're proactively reaching out in other areas. So co-chairing the Cautery Inquest group as an example of DOJ wanting to lean in and work with health. So we need to find a way to do that. I think, and we consciously put in the paper that it will require a dedicated resource, because if we don't have additional dedicated resource, we won't do the issues justice. The other opportunity that we have, and I do say it as an opportunity rather than a challenge, Ciara, is that in terms of timing, we're coming up to the development of the next sort of policing plan. We've spoken briefly here around the development of a strategic approach to organised crime. We're talking about a new community safety strategy. There's the consideration around the next iteration or the mainstreaming of the work under the executive programme for tackling paramilitarism, organised crime. All of a sudden, we've got 4 or 5 big strategic issues in the justice space that we need to somehow land and align. And I don't think we should have 4 or 5 separate strategies. We ought to think really, really carefully about how do we align and maximise the value of all of those. Because a phrase I've heard recently, and Katie and I were talking about this the other day, is Northern Ireland, we used to launch ships, now we launch strategies. So the strategy for me isn't the answer, it's the action plan and what impact it makes on local communities, and whether people feel 2, 3, 4 years down that we are starting to break down those social barriers that have existed for so long. So we're at the very, very early stages, Ciara, is the honest answer. We're doing a lot of desk-based research at the moment. We're doing jurisdictional comparisons, looking at GB, colleagues in Ireland, but further afield, given our international footprint, to say who else has done this stuff. You know, how much is it about prevention, intervention, and upstream diversion, with less of a focus on the actual criminal justice interventions? That, for me, has to be the focus of a community safety strategy.
No, that's good to hear, and I think there's ongoing really good work. Anyway, it's not to say you have to wait on a strategy. There's loads of excellent work, and as you say, that collaboration and continuing collaboration can only bring new ideas and new work. So, no, thank you. I appreciate that.
Sure, it probably links back to a question that Deirdre asked there about the Elm Street bonfire site and the collaboration around that. That was the site, traditional bonfire site, and it wasn't for a number of years. Then the bonfire returned to it in North Belfast. Complicated by 4 different landowners, DOJ requisitioning the land and having an interface fence across the front of it. I'm in danger of throwing flowers at the former communities minister, but I'm going to do that shamelessly anyway, because it was the development of the Dunkern Gardens study that provided the context for the regeneration of that site. It's a derelict piece of land that lay for far too long in a disadvantaged area, but now, as Judy says, the housing-led regeneration is the answer to that. Elsewhere at other interfaces, we have been able to, thinking of Serpentine in North Belfast, working in partnership with Belfast City Council, replace a playgroup in the multi-use games area, and in doing so, remove a former high interface barrier, a security barrier. And I didn't maybe find this on that point. I hear what you're saying about the defensive architecture and stuff, and there is a lot of that, particularly in urban areas. Our focus primarily, though, is on those barriers that are there, typically referred to as peace walls, that are there under the security legislation for the preservation of peace and maintenance of order. Mark mentioned 1/3 removed, 1/3 reduced. Some of those reductions are quite significant. Ciara will know, along Jerry's walls, most of what was there is gone, as Mark said. Flack Street, people in Ardoyne would tell you that we removed the interface barriers. Well, we did, and it closed off the street for 35 plus years, but we did replace them with a automated gate which opens and closes now 16 hours a day. It's a massive improvement, and the amount of traffic and pedestrian access that's created, the additional regeneration, housing led and retail led in that area. So collaboration is easy to say and hard to deliver, but genuinely DFC, DOJ, the Invest NI, the International Fund for Ireland are a really critical partner, and the community groups that they fund and that also exist. and the elected members coming alongside in North Belfast and Adam Street was critical to coming up with a shared plan that won community support. Now, we haven't built anything yet, but the plans are in, the site's sectioned off, Invest NI are realigning the site. It's a positive story. And there are a few others in other areas that were traditional bonfire sites. Hope Street again is another one in the city centre that is down for redevelopment. So that's always positive. But I do hear the point you make, Chair, about the removal of space for cultural celebration and the acknowledgement of that. It's a consideration. And finally, just on that defensive architecture, Brandon Hamber and you probably know from Munster University and David Cause have done some work around what they describe as that sort of hidden interfaces, that defensive architecture. So we do extend our brief to have those conversations.
The balance there is too to make sure that people still feel safe and they're not going to be subject to antisocial behaviour as a result of the removal. So the balance has got to be struck, and it's a difficult line.
Subtle bits though, it wouldn't be the critical interface ones for me. It's more the defensive planning from the past in terms of the conflict and where those barriers are now seen as economic barriers, particularly in working class communities. And that's the concern in terms of access to jobs and and even people's perceptions that they're locked out of these things. It's probably more in an urban setting than a rural, but yeah, it's a key area. So.
Okay, thank you, Doug.
Yep, thank you, Chair. Mark, thank you for your presentation. The injured on duty consultation has it started yet? It's due to start at the end of March. Has it started? Could I just ask, who's that consultation going to be with? And how is it going to feed into how the review of the policing board is going to work? Because there's lots of concern about injured off duty being under the resource committee of the policing board, who don't necessarily have the tools to be able to deal with that. So could you maybe just explain how that's working, and also how we're dealing with this issue that's come up about the retrospective injured on duty claims that's coming up here, where there's people possibly going for a legal case, and how we're dealing with that, because I'm not sure that's been addressed just at this moment in time, if that makes sense.
Yeah, it does. Thank you, Doug, and I'll say a couple of headlines, and then Lynn, if you don't mind picking up the detail. I mean, in terms of the consultation has started, so it launched on the 26th of March, so that's out for 12 weeks. It's out there with stakeholders, it's out with Police Federation and others. And clearly, no predetermined outcomes, so we'll see what the analysis of that consultation tells us. That will allow us to develop it. I mean, the four key areas that underpin that consultation are the recommendations from the NIAO report. And they centre on things like, is it fit for purpose? What is the purpose of IOD, and is it value for money? So the public purse is in there. Secondly, it's quite a complex process, so how can we simplify that end to end and streamline the process for IOD? Thirdly, there needs to be a new case management system, and that's linked to the previous point around streamlining. And also then to start to close the gap on some of the wrinkles that there are within the existing system and some of the frustrations that there are. So those are the four recommendations on which the consultation is based. It's out there. We'll see what stakeholders say. Policing board will absolutely be a critical stakeholder therein, but Lynn, do you want to add some detail to Doug's question?
Yeah, I mean, in terms of the roles and responsibilities of the PSNI, the Policing Board and the Department, they will all form part of the consideration after the consultation closes. It's one of the things that has been on the cards for quite some time now, that we will look into that. But there's a choreography of events that have to take place to enable us to then start looking at the roles and responsibilities.
And how do we narrow this injured on duty claims to somebody who's done it as retrospective? Because at the minute there's different claim dates. So somebody who's doing a retrospective injured on duty claim is being said, look, you'll get it as of when you were injured. Some are getting it as you'll get it as of when somebody is diagnosed a psychological injury. But the regulations clearly state it should be from the date of retirement. When are we going to bring that into line so that all of them are from the date of retirement?
That's all being considered as part of the whole consultation process. All of those issues have been taken on board and will be looked at in due course.
Right. And sorry to labour this then, does that mean then we're looking at how we manage this whole process through the resource committee of the policing board? Is that going to be looked at?
The whole process, including the department, the policing board and the PSNI, the roles and responsibilities of each of the three organisations will be looked at.
Because I know elected reps are uncomfortable with some of this because they're not subject matter experts on medical issues, and therefore they are adhering to what the selected medical practitioner is saying, even though they don't fully have an understanding of it. So it's that sort of concern. But look,
it will all be considered in the whole.
Yeah, it's all up for grabs, Doug. Absolutely. So there's nothing being excluded from the process.
Okay, good enough. Thank you, Joe.
Right. Everybody, that's it. Look, can I thank you so much? You can appreciate that your area of work has huge interest for all of us, I think, as it was borne out in the questions. So thank you very much for taking the time. We really valued your briefing. We look forward to working with you going forward, and no doubt we'll see you again. But again, could I apologise for having kept you waiting outside for that length of time? Thank you very much.
Thank you very much.
Thank you. Members, while we're changing over, if I can refer you to agenda item 7, which is the Criminal Justice Bill, proposed LCMs, which is at page 69 to 106 of your pack. So if you can have that up and ready. While everybody is refreshing, can I just remind you that the committee considered a written paper on the proposed legislative consent motions in relation to the Criminal Justice Bill at its meeting on the 21st of March and agreed to invite officials from the Department of Justice to provide oral evidence on the proposed LCMs. The committee also requested further information on a number of matters, and the department's response is included in its most recent briefing paper. So I presume that Veronica and Jane are outside, are they? The background to this one is where it's the time, essentially, that's a problem, isn't it?
The Attorney General spoke for a lot longer than I was expecting, didn't he?
Yes, but the issue with the legislative consent motions is also the time frame in which the Minister has to bring them, and we've got to consider them. And so a couple of issues of time there, Doug.
So I think so.
Yeah. Dr. Holland, how are you?
Good, thank you.
So we have with us members Dr. Veronica Holland, who's the head of Organised Crime Branch, and Jane McNeil, who's the deputy principal of Organised Crime Branch. Ladies, could I apologise for our delay?
We knew it was running on. So
we've had a lot of evidence today, and it has been running on. So sincere apologies for that. But obviously this is a serious issue for us. So we'll invite you to make your presentation, and then a number of us undoubtedly will have questions. So I'll hand the floor over. Thank you.
Good afternoon, and just to say thanks, I suppose, for the opportunity for Jane and I to come and brief you in relation to the Criminal Justice Bill and the legislative consent motions issue. It's much appreciated. What I was planning to do was just spend 5 minutes, broadly speaking, going through the provisions that are in the bill, both the devolved and the reserved and accepted matters, and then about the same amount of time dealing with the committee's queries from the last meeting, if that seems okay in terms of the approach. I suppose the first thing to say at the outset before we get into the detail of the provisions in the bill and the legislative consent motions and memorandums is, I suppose, just to stress really that the Minister appreciates that the preference would be obviously for legislation to be taken through the Assembly where that's possible. That said, I suppose at present, given the constraints on the legislative programme, it wouldn't be possible in relation to this bill to achieve equivalent provisions within the same time frame. It's likely that it would be the next mandate before that would be being brought forward if it were to be taken forward by the Assembly, and if not included by this bill, if it were still to be through Westminster, it obviously further delays that obviously in terms of the time that we have available. So I suppose that's one of the key issues to stress first of all, and obviously it would also give rise to a disconnect between the provisions that we have locally, some of the protections and safeguards that are in place on offences compared to what may be available in GB. So the Criminal Justice Bill contains a range of measures for Northern Ireland, and they're primarily dealing with matters related to serious and organised crime, but there are also some measures in the bill that would provide protections to victims of crime and also deal with abusive behaviour more generally. So in terms of devolved matters for which an LCM would be needed, the first area deals with new offences related to articles used in serious crime, and this would cover things such as vehicle concealments used to transport illicit goods, templates for 3D printed firearms, components, pill presses used in the supply of illegal drugs, as well as electronic devices used in car theft. There will also be new offences in relation to assisting or encouraging serious self-harm in relation to individuals, and that will apply to both direct assistance or indirect through verbal or other electronic means. A third area in the bill is providing clarity in relation to current legislation on administering harmful substances, what you will more commonly know as spiking. I think there's a sense that there is already legislative cover in relation to that issue, but the bill is providing, placing without doubt that that offence is covered. There's also provision made for corporate bodies or partnerships to be held criminally liable where individuals carry out commit any offences while it's been undertaken with the authority of that organisation. And the bill also provides for police and other law enforcement agencies to automatically access the DVLA driving licence database, not the local DVA one. So in respect of that one, it's generally a reserved matter. It's dealing with an England and Wales issue, but there's a local element in terms of its application and in terms of the impact for policing locally, as well as having regard to a code of practice. So that's where the LCM element would apply in relation to that. A further aspect to be included at House of Lords committee stage, and we had been hopeful that that would have been included at House of Commons stage. That hasn't been possible due to wider amendments being brought forward by England and Wales in relation to that, is confiscation reforms, so improving processes and systems in relation to dealing with stripping convicted criminals of proceeds of crime. So that's one of the key aspects that would be included in the next element of the bill for Northern Ireland. And then the final area on devolved matters at the moment in the bill relates to serious crime prevention orders in terms of who can apply for those. It will remove the limitation on police only being able to apply in relation to terrorist-related cases, and it will also enable those orders to be brought forward where there's an application on acquittal or when there's an appeal. Currently, those orders can only be brought forward where there's a conviction. So with the exception of the confiscation reforms, the other ones that I've gone through in terms of devolved matters are either all currently in the bill or will be included in the bill at the end of the House of Commons report stage, and that's currently scheduled for later this month. So those matters would be the subject, with the exception of the confiscation reforms that I've mentioned, those would be the subject of the first legislative consent motion and memorandum that we would be bringing forward. And our hope would be in relation to that could be brought forward after House of Commons report stage. As I say, that's tentatively late April. We would hope to be able to table the memorandum the day after that bill is reprinted, and hopefully around about the time after we go to the executive. So we're scheduled to have an executive paper hopefully considered on the 25th of April. We would hope to be in a position to be laying that first memorandum after that executive meeting. So then in relation to the second legislative consent motion and the memorandum associated with that, I suppose a number of points to make in terms of that there. The timetabling of those provisions, I suppose, in terms of those matters that are going to be in the second part of the bill, or the second LCM, apologies, is due to really, I suppose, the sequencing and timetable of the provisions being included in the bill as it passes through Parliament. Those can't be included or dealt with through a memorandum until such times as those have been tabled and the amendments made to the bill in Westminster. So that's the reason why we're having to do essentially a phased approach. We can't do those future measures until those amendments have been made. So there's that phased approach or two-staged approach that we're taking forward. The other thing, I suppose, really just to flag, and that will be of interest to the committee, is that since we drafted the paper and issued that to members, Home Office and Ministry of Justice have indicated that they're considering a number of further provisions, largely in relation to sexual offences and those matters that are dealing with vulnerable adults. Some of those aspects, final decisions haven't yet been taken as to whether or not those are to be included in the bill, but there are things coming forward and only recently brought to our attention that the Minister will obviously want to consider in due course. So the ones that are being looked at by Home Office and Ministry of Justice are additional provisions related to registered sex offenders in terms of the notification requirements associated with those individuals, a possible new offence related to the making of deep fakes, so where someone's head has been superimposed on images or videos which isn't of them, and the possible extension of a current possession of a paedophile manual offence. There may also be a new offence being brought forward in relation to cuckooing, so essentially where someone is exercising control over another individual's property and doing that through coercion, intimidation, threats. For those of you that have watched Line of Duty, you'll be familiar with that scenario in relation to one of the individuals in that show. So as I say, we haven't had decisions taken in relation to those, for some of those provisions as yet, by Westminster. And the Minister will obviously want to consider, once it's known which of those measures are going to be included in the Westminster Bill, as to whether or not those should be extended to Northern Ireland. So there's a small number of provisions which will also be included along in that second LCM. Our original thinking had been it would just be the confiscation reforms, but there will be potentially a small number of other criminal justice matters. So alongside those devolved matters that I've just touched on in relation to the bill, I'll just quickly go through the reserved and accepted matters, which obviously the Assembly can't legislate on. So these include prohibiting the supply, possession and use of SIM farms. So that's basically facilitating multiple SIM cards being used for fraud, phishing and other scams more generally. Also a new offence of possessing or supplying an article used to facilitate fraud by electronic communications, enabling internet domain names and internet protocol, so websites to be suspended where they're being used to conduct criminal activities, and there's also provision for a suspended account scheme. So that will basically enable recovered suspected criminal funds to be used for other purposes, and that would apply to Northern Ireland as well. In addition, measures will be introduced that will enable applications to be made to impose terrorist notification requirements on certain offenders, and there are also some provisions in relation to police appeals, but they're in relation to Ministry of Defence Police, so again falling into the gambit of Westminster legislating on that. So as I say, that's kind of a quick overview in terms of kind of the provisions in the bill at the moment, and then I was just going to quickly address the main queries that the committee had at their last session, if that's helpful. I suppose just before I turn to the next bit, I don't know if members want to ask any questions in relation to those provisions, or would you just prefer and do all of the questions at the end?
I could do all the questions at the end.
No, that's fine. That seems sensible.
Allows you to keep your flow.
Yeah. No, that sounds good. So it does. So the first query had been in relation to engagement with operational partners, and obviously there's quite a number of provisions in the bill, and it will have ramifications for a range of operational partners. So we have been and will continue to engage with them in relation to that, and partners have been supportive of the measures that are being brought forward. I think some of the main aspects are for them is where there are provisions in the bill which ensure that there is consistency with the approach that is being taken either in England and Wales or consistency across the whole of the UK, and obviously that's something that we'll continue to do as the bill is being progressed, and then with the future implementation of the provisions. The second one then related to the Article 2 considerations. So in terms of that, we've engaged recently with both the Human Rights Commission and the Equality Commission. They came back to us to advise that they weren't able to provide detailed advice in the time that was available, but they did refer us to a range of documentation and guidance, which was incredibly helpful in terms of our considerations in relation to that. We've also looked at Executive Office guidance in relation to that matter and have carried out an Article 2 screening assessment. So at this... The other thing I suppose I should say is that while there is work being undertaken locally in relation to that, there's also an onus obviously on Westminster as the bill owner to do that as well. So from our perspective, we don't consider that Article 2 is engaged in relation to the provisions of the bill in terms of impact on equal opportunities, equal engagement or discrimination. Obviously the measures that are being introduced will apply across the board, and they shouldn't impinge adversely on the rights of any particular group. In addition, there's obviously a range of measures that are being introduced that would further protect potential victims of crime. In terms of kind of the Home Office Ministry of Justice aspect, the initial indications from them, and they haven't fully completed this, but the initial indications from them in terms of the provisions on the bill is again that they don't consider there's an impact from an Article 2 perspective, and we've also engaged with legal advisors within the department, and they're content that the provisions in the bill related to Northern Ireland are Article 2 compliant. So that's kind of the position in relation to that aspect. And then the last query was in relation to the operation of any fallback provisions. I suppose at this point I was thinking it may be helpful just to reflect on the indicative timings. We had hoped that there may have been a further update from Home Office in relation to bill timings. At this point there hasn't been, but obviously we'll continue to engage and liaise with the clerk in terms of any further information we get in relation to that. So we understand that the earliest for House of Commons report stage is likely to be the last full week in April. I think tentatively we're looking at the 23rd and the 24th, with the earliest that further amendments would be made, would be tabled and made, being late May and early June. And obviously, as I say, we can't bring forward a memorandum when amendments are tabled, given the current provisions in relation to standing orders. We would have to wait until those amendments have been made. The one thing that I would stress is that these are the very earliest dates, and all of the indications that we're getting in terms of kind of discussions with counterparts in Westminster, as well as the number of additional measures that are still being brought forward for the bill at this stage, is that I think there's likely to be further slippage in terms of that timetable. I think we will probably collectively be doing well if the bill is coming to us and we're able to bring forward that memorandum for kind of the second half of June. I suppose some of the added difficulties in relation to that are in terms of kind of the sequencing or the alignment of our timeframes and recesses here compared to Parliament. Obviously, they sit later than the Assembly does. Their recess doesn't start until I think the last week of July. While they start roughly the same time as us, I think certainly from looking at previous years, it would appear to be the case that our first plenary will tend to be slightly later than theirs will be. I think possibly the second week of September. And then obviously for Parliament as well, whereas their first plenary would kind of be the very start of September. There's also the fact that there's likely to be a conference recess. So there's probably only 2-3 weeks, obviously, and a number of you will be very familiar with this. There's likely to only be 2-3 weeks in September where Parliament is actually sitting. And as I say, because there is kind of that differential in terms of our timings, it adds, I suppose, to it further limits the amount of time that we have available. So as I said, we can't make the memorandums, unfortunately, until the amendments had been made to the bill. The Minister had written to the Procedure Committee just to flag this. It's something that I think they had looked at previously and are considering in terms of the other jurisdictions. Memorandums can be led whenever amendments have been tabled. So it gives you a further 4 weeks roughly. It won't always be as much as that, but it does give you a bit of extra time. It's something that they're looking at. I would like to think that there will be a positive response in relation to that. Ultimately, I think, however, it's probably unlikely, and I don't have anything on which to base this, but I think it's probably unlikely that change would be brought forward before these LCMs and memorandums would be coming forward. But obviously that's something that is being looked at more generally. And then in terms of the fallback approach, to provide some further information in relation to that, again, I suppose just to be clear, our preference is that the normal procedures would apply, that this is being considered by the committee, it is being reported on by the committee, that we can have a debate in the Assembly, etc. I suppose what we were trying to do in terms of this paper is kind of work through all of the possible kind of options and scenarios and see if we end up into worst case scenario, what may we be looking at. But in terms of that fallback approach, it's something that the Minister's only considering if it's not possible to pass that second LCM for the outstanding provisions within the timetable available. So only if needed, this would entail Westminster legislating for Northern Ireland on the confiscation reforms, plus any of those other criminal justice measures that I mentioned. In either the absence of an LCM or a legislative consent memorandum having to be tabled saying that we're not seeking consent, and that can't be done on the basis that there isn't the time available. If this scenario were to be progressed, the provisions, what would be suggesting in relation to this, and as I say, I'm hoping that we never end up in this position, but the provisions would be subject to commencement by both, with the agreement of both the Executive and the Committee, and the Minister also making a ministerial statement to the Assembly in relation to this. And I suppose our thinking in relation to that was, and you wouldn't normally have a process such as that associated with LCMs and measures being brought in, is that it would still afford some form of local control and assembly control in relation to that. A further matter that we've considered, and my apologies that I hadn't picked this up for the most recent committee paper that was provided, and I'm sure members will be well aware of this in relation to further LCMs, or the second LCM that we were referring to in relation to the confiscation reforms and those other criminal justice matters, is obviously that standing orders provide that where a further LCM is being brought forward in relation to the same bill, it's not compulsory, I suppose, for want of a better phrase, for those ordinary first LCM provisions to apply in terms of the time given for a committee to consider and report, and a memorandum and debate only being brought forward after a committee is reported. As I say, in no shape or form do we want to be in that territory, and I think, all being well, that won't have to be, the fallback position, I suppose, in that I've just covered. We won't have to hopefully end up in that territory, because I suppose ultimately there are those provisions in relation to the further LCM, albeit that our preference, and as I said at the start, our preference is very much that there is the time available for the committee to consider this, to report on it, and then the motion and the memorandum being brought forward. But as I say, it's really because we're conscious of how tight that time frame is in relation to the Westminster timetable. I think it's only going to get worse. The indications and sense that we're getting at the moment is that there are probably likely to be another few weeks added onto that time frame, if not longer than that. And as I say, because just of the sequencing of provisions in relation to the recesses locally. So I suppose in relation to that and what I've covered, we'd be keen to hear the committee's views in relation to whether or not that may be something that could be considered in terms of potentially a second LCM being brought forward and a memorandum being led without the committee having had the opportunity to report, and that would be very, very much dependent on what the timings were looking like at that particular point in time. I suppose our thinking was it may potentially enable a second LCM to be passed even with tight timings, and while not ideal, I suppose what we were thinking in terms of that scenario was if the committee didn't have the time to report, it would still allow a debate to be held locally in relation to those provisions. So it would be a much better kind of, I suppose, I'm thinking from my perspective, for assembly involvement, it would be a much better position than potentially having to go down the route of the fallback provisions that we've alluded to, whereby potentially it's Westminster legislating to us without there having been anything in terms of an LCM locally. So that's kind of an overview in terms of the bill provisions, and then also in terms of those committee queries and also the whole kind of fallback approach. So as I say, very happy to discuss any of those elements and answer any further queries that the committee may have.
Just a raft of minor issues. Right. I suppose from our point of view, I'll go first and I'll open it out. From our point of view, I suppose the concern is that this is a very wide-ranging bill. And now we've got even additional issues flung in. We have no concept as to what amendments could end up being tabled on this, and we have certainly I have some reservations about essentially giving a carte blanche without any idea what could be included, and just saying yes, we will allow this to apply to Northern Ireland. So I certainly have some reservations along those lines. I'm not entirely clear, and perhaps you could help me to understand, with regard to the delays now in the second part around confiscation reform and everything else that's been added in. Surely the fact that there are additional delays in there and additional significant issues contained within that now will afford us some more time, because it's going to take that some time to work its way through the parliamentary process. So does that not afford us some degree of flexibility, or have I completely misunderstood that?
I suppose if I try and address those two aspects, I fully get where you're coming from in terms of that first point around additional measures that you may not be aware of. Certainly I've referred to all of those that the department is aware is being brought forward at this stage, but I appreciate where you're coming from in relation to that. I suppose it may be helpful if the committee could almost think of this in terms of the two LCMs separately, because what I do think the committee should hopefully be able to do is to give a very clear indication in relation to that first LCM, where it's essentially the things that we have mentioned, the content is known, what's going to be covered. The second LCM, as I say, is really, I suppose, at this stage, as far as we're aware, is dealing with the confiscation reforms, some sexual offence related matters, albeit that, you know, there may be, you know, there could potentially be other things that are suggested. So it would be helpful to have a committee view in terms of kind of that first LCM, which I suppose we know what the content is, and then perhaps a separate or different view in relation to the second LCM. In terms of the timing, fully get where you're coming from in terms of if that's being shunted, does it not afford us more time at the other end? I suppose potentially it could do. I suppose for us at this stage, we haven't been able to get further updates in relation to when those definitive dates, I suppose, in terms of when those House of Lords amendments are going to be tabled or going to be made, what the date of their last amending stage is, and that will all very much determine what the kind of window is that we have to play with. I think the difficulty is that depending on when an election may be called, that could still be quite short. You know, that could be, you know, there may not be an awful lot of additional time at the other side. And as I say, just because you have the difference in kind of the recess periods for the Assembly and Parliament, plus the fact that I'm assuming it may not be the case if an election is being called shortly after that, if there is the conference recess. So I suppose it's quite unknown at this point what our window is going to be in terms of kind of the period for that bill being taken forward. There may be an additional week or two, but again, because of some of those other factors, it may not necessarily, you know, when Parliament goes into recess and when we go into recess, etc., it may not necessarily give us much additional time over and above what we're looking at the minute. Initially, Westminster had been indicating that they wanted the LCMs and the memorandums approved by the end of June. They were indicating to us that was the last amending stage. I think it's going to be into September. I think the difficulty is we just don't know what our time frame is the other side of recess, and I appreciate that's not particularly helpful from a committee consideration perspective.
Is there a number of things that we need to understand? I mean, at this stage, my view would be that now with regard to the second LCM, I think that does afford us a bit of time. We don't need to make a decision today on that one, but I think we can give consideration to the first. But within that, even there are a number of things that we require to understand. Are there delegated powers within that to the Secretary of State? Because it's fine for the Minister to suggest that she wants local input and so on, but if some of this stuff is delegated to the Secretary of State, then there won't be any. So we need to have clarification around issues like that. Mm-hmm. Can you give us that clarification?
There's some provisions in relation to, I suppose, a power for Secretary of State to bring forward regulations. My understanding is that it largely relates to things around, for example, the serious crime prevention orders, the notification requirements associated with those. What we had asked for was a power in relation to Northern Ireland being able to take that forward. I think the concern from Home Office was in relation to those types of provisions was that Northern Ireland wasn't doing something that was different from what the rest of the UK was doing. So I think that seems to be the rationale for those powers resting with the Secretary of State in relation to that. There obviously would be engagement with us in terms of what the content of that would look like. As I say, for a few of the provisions we had asked for powers locally, and that was kind of the position that was arrived at in relation to that. We obviously had provided reassurances that we wouldn't want to be stepping out of sync or out of kilter with the provisions in the rest of the UK, but I think there was a sense that the preference was that essentially it was one set that was being brought forward in relation to regulations associated with that type of measure.
And I think that we understand that. I mean, first of all, there's no point in reinventing the wheel. And secondly, we would not wish to put Northern Ireland in a position where it would be exposed to criminality in a way that the rest of the UK was not, and would become the weak spot, or rather the sweet spot potentially for criminals. So we are mindful of that, but I suppose there's still this issue about what role this committee would have in scrutinising you know, subordinate legislation. There are issues around, you know, the Minister has given, I suppose, some assurances that even in terms of the fallback position, that she will, you know, she'll make statements and she'll bring information here and those and all of that. But I mean, you don't know what can happen in the course of a day. So, you know, in circumstances where personnel were to change, you know, where's the guarantee then for this committee? You know, and for scrutiny of these LCMs. So you can understand from our point of view there are still some issues that we would need to see clarity on. I'm going to open it up to other members, and then there may be a few issues that we just need to...
Maybe apologies for interjecting. In terms of that, you know, and I suppose the other thing that I would say, I think, having looked at those provisions in relation to the further LCM, to me that is our more immediate fallback position, albeit that, again, even for it, we wouldn't want to be in a position where timing-wise the committee was unable to report and a debate then to be held after that. To me, that is kind of our most immediate fallback position. And then I suppose in terms of the further fallback ones where the Westminster was potentially legislating for us without there having been an LCM, you know, certainly the intention, if we ever got into that territory, and I'm hopeful that we wouldn't be, what we would want is a commitment from the government in Parliament to be stating that these measures are to be considered and agreed by the Executive and Committee before they're commenced locally. So I suppose that would be an additional element in relation to kind of the confirmation or obligations on the Department and future Minister to take that forward.
What's the likelihood of you getting that from the government?
My understanding is that there has been something like that before. I don't see that as a major issue for Westminster to commit to, because I suppose essentially in terms of those provisions, the Minister's agreement has to be sought. If we weren't having that further engagement with committee, with executive, ministerial statement, etc., which wouldn't normally be kind of part and parcel of this process, and anything being brought forward in terms of commencement of provisions, the agreement of our Minister has to be sought in the first instance. So Westminster can't commence for us without her agreement. So I see that as something, you know, I don't think that should cause any issues for a minister or government spokesperson in the Lords, you know, making a statement to that effect. And I think it has been done before in relation to, possibly not in relation to something like this, but I think there has been something like that previously where there have been commitments and assurances given by ministers where something is going through Westminster and it has those implications locally.
Anybody else have any questions?
And I'll also apologise in that I know that's a lot to take in and it's very techy.
Just to reiterate some of the concerns that you raised, with the same issues as well, just in terms of side of it, and particularly with the second LCM, and just again around the delegated powers, particularly to the Secretary of State. Does that too need the permission locally in terms of those delegated provisions? You touched on it there, just saying that the Minister here locally would have to, in terms of the commencement, does that include the delegated powers then that you spoke about in terms of the Secretary of State's role?
The commencement powers would, I suppose, really be in relation to those provisions generally being brought in, you know, and that obviously, and you'll be well aware of this in terms of commencement provisions generally, it's the Minister takes a decision in relation to that and obviously advises the Assembly in relation to that, as I say, where there are things that are having an impact on Northern Ireland and are being commenced or regulations being taken forward on our behalf. Again, there would be that engagement with the Minister and the Department in terms of that being taken forward.
Okay, I suppose just a couple of other things, ladies, if you'll bear with us, that we just want to tease out with you. The Department states that it'll be consulted on the Code of Practice for the receipt and use of information in relation to access to driver information. Could you give us some indication what bodies or organisations will you engage with locally to inform its input to a consultation into the Code of Practice? And the other thing is, with regard to these additional measures now coming up in the second LCM, we'll refer to it as the second LCM anyway. You know, what consultation has there been around those issues, or what will there be? What's the plan there?
I suppose at this stage, I'll take the second one first. At this stage, I suppose, because at least some of those are unknown in terms of whether or not they will be brought forward locally, or whether even Westminster will necessarily be legislating in relation to that. So I suppose there's no firm decisions taken in relation to that at this stage. There will be engagement as part of those measures being taken forward. There will be engagement with operational partners in terms of those measures being progressed. And then in terms of the first one around the DVLA and the code of the code associated with that, the guidance, that guidance will largely be for police. So we would see one of the main points of engagement in relation to that being with police in terms of ensuring that they're content with what is in that, because obviously there is that local application. So that would kind of be the position in relation to those two aspects.
Okay. Does anybody else have anything they want to add or ask? Clark, are you happy? Yes? Yeah. Okay, that's fine. Okay then, ladies, can I thank you for your evidence? That's been helpful. I suppose I am conscious that, I'm just getting a note.
That's no problem. And obviously if there's anything else that kind of should come up in further discussion, more than happy to engage with committee clerk in relation to that, or provide any further briefing.
No, I think that's fair enough, and I appreciate your circumstances around the first one. I do think that we don't need to take a decision today around the second one. I think we do have a bit more time to give consideration to that, particularly in light of the new information that you've given us today, and those are not small issues. So I do think it would be wise for us to take our time and take a look at that and give it a bit of consideration. With regard to, we'll have a discussion now about the first LCM, and certainly we will write to you with any decisions that we take. But in the interim period, could I thank you very much for coming to discuss it with us and for being so helpful.
Thank you very much for your time. It's much appreciated.
No,
and I know that this isn't an ideal situation for any of us.
No, I think it's difficult for all of us, because nobody wants to be in this situation.
No.
But we're grateful to you for taking the time, and once again I apologise that we kept you so long.
Oh, not at all. We knew that things were running behind, so thank you.
Thank you very much. Thank you. Okay, members, so I suppose there's a couple of questions for us then, and I would like to seek your views on whether you're content in principle for legislative consent to be sought for the provisions that extend Northern Ireland, which were in the bill at the end of the House of Commons consideration stage, and then we'll move on to this. I think the second part, I think are members content that we just hold on the second LCM for now?
Yeah.
All right, well, with regard to the first part, I think because of the nature of this bill being so wide-ranging, and we really don't have any concept as to the amendments that could come forward, nor actually be made, because I appreciate the Minister's letter refers to UK government amendments, but amendments can come from anywhere and be accepted. So I think we all have some reservations around that. So perhaps our way through it is to agree in principle with the LCMs, but noting that in advance of its passage through Parliament, there may be changes, that what we agree to is what we have seen in terms of the bill as it was introduced, and the issues that have been listed there, I think at page 83 of our packs, and that might be our way through it, which affords us some degree of protection should there be things in there which arise in the course of the amending stages that cause us some concerns. We don't want to leave Northern Ireland exposed, but by the same token, so do you see that list there? So
paragraphs 5 and 7.
So it's paragraphs 5 and 7. So the devolved areas to be included in the first LCM are clauses 1 to 4, offences relating to things used in serious crime, theft or fraud. Clauses 11 to 12, offence of encouraging or assisting serious self-harm. Clause 13, administering etc. harmful substances, including by spiking. Clause 16, criminal liability of bodies, corporate and partnerships where senior manager commits offence. This is because I don't have my glasses on. And clauses 42 to 45, serious crime prevention orders, and then paragraph 7. which you can read there, which is access to driver licence records, and the police having regard to code of practice, wider policing law enforcement purposes and so on. So, I mean, we could cite that in our minutes, and then it's very clear the things to which we have agreed.
Yeah.
And I think that that does afford this committee and our parties a degree of protection. So, do members have views on that?
Well, I'm content that we do exactly that, what is written there, and nothing more. And then see how its passage is, and then see where we have to move from that, and react accordingly. If that means an emergency meeting to deal with some amendments that come through, then that's what we need to do.
Is there time for the first LCM this bit then, when that's going to come through in terms of the amendments? Any further amendments? Is there?
It's going to be put back, you see?
Nobody.
We don't know yet, do we?
No.
Like, we don't have a specific time yet.
No.
Sorry, through you, Chair. I don't think there are any proposals to make any amendments to what they think it's going to be in the first LCM. I think it is.
It'll be the
That is
second.
what they
Okay.
expect to be in by the end of the House of Commons report stage,
Yes.
and that's what they're going to put in the first LCM.
Okay.
The second LCM is where the committee has agreed to kind of not to progress any decisions at this point in time, because the officials added a lot of detail actually today.
I suppose, and it'll be those contents, then, that Naomi will bring on the 25th to the executive then
Yes.
for...
Yes, Chair, I think that's what the officials were indicating.
yeah.
Yes.
My feeling that is, again, that's what's expected, not what is known.
No, that's no,
No.
exactly.
No.
Yes.
You know, and maybe I'm just acting with an abundance of caution, but you know,
You don't know.
I think I'd rather.
Yes.
Yep.
That's fine.
Yeah, no, that's
That's another
agreed on
approach
that.
right to the second.
Pardon?
What you could consider in the second. If you don't have time to report, you can publish it.
Yeah, and that's the thing. Kathy's just saying here, if the committee doesn't have time to report on a second LCM, it could still agree to publish any correspondence it might have to help inform the debate.
Yeah.
Now, none of that's ideal, I think. I
No.
think we'd much prefer
Yeah.
that the committee got to work through its programme as usual, but hopefully that gives some succour to the department that it can progress a bit, and certainly affords us and our parties some
Level
protection.
of, yeah.
So are everybody happy enough then?
Agreed.
Yes.
Lovely, thank you. Okay, let me see where we are. So we're going to hold then on the second LCM for now, and we'll give it consideration at not the next meeting, but the one after. Yes. Also, the next meeting's the visit. Isn't that okay?
Yeah, we can do, yeah.
Or whenever is most appropriate. We'll leave that with the clerks, I think. So let's see where I am. Yes, agenda item 8, which is statutory rule. Yeah. 2024/38, the Police Pensions Amendment Regulations, Northern Ireland 2024, which is at page 107 to 131 of the meeting pack. So this rule came into operation on the 1st of April and will remove the risk of legal challenges for disability discrimination relating to ill health exclusion benefits following a concession made by the Home Secretary regarding such a legal challenge in the equivalent England and Wales police pension scheme. It will introduce a revised, or maybe it has introduced a revised employer contribution rate as a consequence of the 2020 police pension valuation, amend the regulations relating to the forfeiture of a beneficiary's pension within the Royal Ulster Constabulary Pensions Regulations 1988 and the Police Pension Northern Ireland Regulations 2009 in order to align with those provisions which the scheme established by the Police Pensions Regulations Northern Ireland 2015, and it will apply technical amendments to correct minor drafting errors in the 2015 scheme. Members, I just want to remind you that the committee agreed it was content with the proposal for the rule at its meeting of the 29th of February, and the department has confirmed that there's been no changes to the policy content since the proposal was considered by the committee. The examiner of statutory rules has raised no concerns regarding the technical aspects of the rule, so are you content with the rule?
Agreed.
Okay, so on that basis, the question is that the Committee for Justice has considered SR 2024/38, the Police Pensions Amendment Regulations Northern Ireland 2024, and has no objection to the rule. Members agreed?
Agreed.
Agenda item 9 is SL1 period products, which seem to be going through each of the departments at this stage, which is at page 133 of your pack. That goes on to page 147. So the department's proposing to make a statutory rule to specify the public service bodies within its remit that will be subject to the duties under the Period Products Free Provision Act Northern Ireland 2022. The specific bodies will be required to establish and maintain arrangements to ensure the period products are obtainable in their premises free of charge for any female who needs to use them. And the statutory rule will be subject to the draft affirmative procedure. Does anybody have any information that they want or anything clarified? There's just one thing that I want to clarify, which is on page 133, I think. Yeah, it is. So the department lists bodies and says that obviously its core functions aren't included, but in the spirit of it they're going to look at it. I suppose the one thing that occurred to me was they're taking account of public facing circumstances, and I wondered about the court service, actually the courts, and whether or not there should be free period products available in the courts where there are members of the public.
Yes, of course.
And maybe we could seek clarification from the department on that.
Yep.
So subject to that clarification, do we want to proceed with the proposed SR, do we want to hold until we get that clarification?
Chair, if we proceed, that allows the department to implement.
It does, but then it's implemented without the courts.
Well, they can give it, I mean...
So you want to proceed, but we'll seek do we have any advice on that?
Chair, sorry, my reading of what the department has sent is that as an agent or as a body of the department, the court service doesn't necessarily need to be specified. Okay. But it's looking to put provision as wide as possible, so we can ask, the committee can ask obviously that will include the court service, but these bodies do need to be specified.
Okay.
I think that's probably where the difference maybe lies. And just to note that the department has actually laid this today. I just think there's probably just been a wee slip up in process there, but it has actually already been laid, so they are proceeding with the rule as well.
Okay. Well,
but that doesn't preclude you from getting additional information.
No, I think that we're content. I mean, the issue here is just to make sure things are available. It's not, it's to try and help. So, agenda item 10, which is vehicle recovery, storage and disposal statutory charges review, which is pages 151 to 176. So the department intends to launch a consultation on a review of statutory charges for vehicle recovery, storage and disposal. The consultation will seek views on whether the charges should be increased to align with recent increases in England and Wales, which would equate to 28% increase in the fees. The proposed uplift in fees is set out at page 153. So are members content to note the paper and to consider the matter further when the results of the consultation and proposed next steps are available, or do you have any information or clarification you want at this stage?
Can I ask, I know they're benchmarking or looking in terms of England, Scotland or Wales, but just even north and south, just because of the border and the way people move about the island as well, so just some comparison in terms of costs.
And can we be sure this is at full cost recovery?
We can check all those things and then we'll hold everything. Once we'll check those things and then we'll hold everything else until we get the results of the consultation. But I suppose the other thing that occurred to me was it's one thing to bring in, I suppose, parity with England and Wales, but then cost of living might be different and level of wages could also be different. But look, let's see what the consultation brings forward.
Here, all of those types of things too.
Let's see what the consultation brings forward and we can check out those queries. Yes. All right. Agenda item 11 is civil legal aid review, which is at page 178 to 239 of the meeting pack. So the department's intending to launch 3 calls for evidence relating to proposals to review civil legal aid, which are aimed at civil society, children and young people and members of the legal profession. The aim of the calls for evidence is to identify any barriers or other factors that may be impacting on access to justice from both the user's perspective and from the perspective of a supplier of legal aid. The department has provided copies of the calls for evidence documents for information, and members should note that these documents are embargoed because they're currently in draft form, and you can see that. I mean, there's typos and so on there. So, are members are content to note the paper and to consider the matter further when the results of the calls for evidence and proposed next steps are available, or do you have any further information or clarification required at this time?
Noted.
Well, the one thing I would like to know is, I note that this consultation is for 8 weeks. And there were references in the course of earlier evidence sessions today about consultations for 8 weeks, when it seems to me that the standard is 12. So I would like to understand why 8 weeks and how the department determines which will be for 8 weeks and which will be for 12, because 8 is supposed to be for emergency purposes. So just to have some understanding as to their rationale, I think that would help us. All right, thank you. Agenda item 12 is the Remote Evidence Centre. So I would refer you to the written paper on the Report Evidence Centre at pages 12 to 24 of your tabled pack, which is being provided in advance of the committee's visit next week. So that pack, a further pack providing additional details on the arrangements of the visit, will be issued to members early next week. And again, I would ask members to confirm their intentions or otherwise to attend with the committee staff. Thank you. The Forward Work Programme. An updated work programme and a draft Department of Justice Forward Work Programme are at pages 242 to 251 of the meeting pack. The committee strategic planning session will take place on the 2nd of May at 1:30 p.m. and this session will be held in the Stormont Hotel. If you're content with that.
Which session, sorry? Which session is in Stormont Hotel?
This is the strategic planning.
Oh, sorry, the planning session. Yes, that's grand. Thank you.
We're going to go away from here. But further details on that will be provided in the coming weeks. Just with regard to the Forward Work Programme, there's a couple of things. I still think there's a couple of days are quite heavy in terms of evidence and some are a bit lighter, and maybe we could have a look at that. But
balancing.
Yes.
Yeah.
But I think that we're happy enough to kind of look at that as we move through, aren't we? And the other issue is with regard to the 25th of April. Members, you'll note that we're due to have the Minister and we're due to have the Chief. And then there's also, I think there's other written work, but then the Director of Public Prosecutions was also to come. To be honest, my experience of the Minister and the Chief has been that actually they're really good in terms of giving you complete and full answers. And they like to engage that way, and I think that's really useful for the committee. It's a shame that our kind of 2 big ticket items are happening on the same day, but I think it would be unfair to the DPP to bring somebody else in on that day. And I think with given the import of the circumstances around budget and the issues that have been raised with us, when we have the Minister in front of us and the Permanent Secretary, the new Permanent Secretary, and when we have the Chief Constable who gets 65% of the budget, I think it would be right to afford them as much time as we can and afford ourselves the chance to question and follow through with issues that we have. Stuart?
And Chair, just to that extent, it would be possible, and I understand the Minister would be available, if we could start at 1:30 that day. That would also provide a little extra time.
Are members content with that?
Yeah.
I think that's helpful. They're the 2 biggest.
One room to the other.
No, dear love you, Mars. We'll make sure that you get something. We'll get you a snack.
You get your sandwich.
No, that's helpful. And you know, I suppose I would like to probably publicly apologise to the Director of Public Prosecutions for rearranging again. But I think it would be an injustice to everybody to bring them in at that stage.
Your experience the last 7 weeks is showing you that.
Well, this is, I mean, but that's the great thing about this committee, that everybody wants to participate.
Yeah.
You know, everybody wants to
And
engage in the
that,
conversation.
in fairness,
And that's important. And actually, the Minister has shown that that's the case with her, as is the Chief Constable.
Yeah.
So why would we not take advantage of that and you know, try and get the best out of the session? So you're asked to note the document. Is there anything else anybody wants to raise about that? No, content.
No,
That's lovely.
content,
Thank you. Correspondence. All right. Correspondence is quite long. There are a considerable number of pages. So there's a correspondence memo and 17 items of correspondence at pages 254 to 765 of your pack. I'm going to draw your attention to 3 items, and then if any of you have any issues you want to comment on or raise, then we can move to that. So I want to draw your attention to item 9, which is a letter from the former chair of the board, Deirdre Toner, which is page 396 of your meeting pack. So the former chair of the policing board is proposing the reinstatement of informal meetings between the committee chair and chair of the policing board. The predecessor committee had agreed that the chairs and deputy chairs would meet during the previous mandate, and this helped ensure clarity around the respective roles of the committee and the board and to facilitate a smooth working relationship. And I think that's helpful because sometimes the boundaries can be crossed. So actually a new chair and vice chair of the board were appointed today, and if members would agree, I think it would be useful if we, or I think it would be nice if we sent them, the chair and vice chair, congratulations letters and wish them all the best for their tenure ahead.
Yeah.
Yes. So are members content then that the vice chair and I and the relevant policing board personnel meet, I think it was proposed quarterly, with the policing board chair, vice chair and officials, or chief executive, and then we will update the committee accordingly following each meeting. Are you content?
Good.
Thank you. Item 14, which is correspondence from Glenn Roberts, the Chief Executive of Retail NI, which is at page 483 of your pack. Mr Roberts has included an invitation for members from Peter McReynolds MLA to the launch of Retail NI's Business Crime Report on Tuesday the 23rd of April. Any member wishing to attend should respond directly using the contact details provided. Members content? Thank you. Item 15 is correspondence from a barrister regarding family drug and alcohol courts in Northern Ireland, which is at pages 485 to 499 of the pack. Correspondence includes a letter from the Minister of Justice dated the 12th of February 24, which advises that an evaluation of a pilot of the FDAC model was being undertaken and next steps considered in conjunction with delivery partners in the Department of Health. I am seeking your agreement at this stage, members, to request an update from the Department on the evaluation of the project and the next steps whenever those are available. Members agreed?
Agreed.
Are members content to note the other items of correspondence as set out in the memo, or do you have any comments you wish to make?
Can I raise one? It's 14.5. It's page 265, and it's actually on page 266 is the last paragraph, and it's in regards to, remember the conversation we had about Access NI for people who are looking after homes for Ukrainians, and I asked a question about, well, what about other asylum seekers who go into hotels? Who does the checks on the staff there? And they've kind of answered that, but they've just basically said, it's up to Mears and it's nothing to do with us. I'm not sure I'm happy with that as an answer. I would rather they gave us an answer and says, what have they checked with Mears to what they're doing? Because if that's a young family and their kids are going out to a school, we make sure the school has all the checks in place. So could we just ask them to expand on that a little bit, please? I don't think it's sorry.
Agreed with.
I don't think it's an acceptable answer.
No, that's fair enough. Members content?
Yeah.
Lovely. Yes, we'll do that then. Thanks, Doug. Item 15 is chairperson's business, and I don't have any items of business. Item 16 is any other business. Does anybody have any other business?
Just very, very briefly, Chair, just a quick reminder to members that the potential new all-party group on access to justice will meet in this room on Tuesday the 23rd of April at 1 o'clock, which is the normal APG meeting time. And I encourage members of the Justice Committee to consider coming along and joining that APG.
Great, thank you. Who did you say is doing the admin for that?
It's a company, Brian O'Connor, but the facilitators are the Law Society and the Bar Council.
So is that the only item of any other business? All right, so date and time and place of next meeting. So the next meeting is going to be at the Remote Evidence Centre on the 18th of April. So the actual next meeting here is going to be on the 25th of April at 1:30 now. It's going to be, yes, in this room at 1:30 p.m. Okay, everybody, thank you very much. That's the meeting adjourned. Thank you. Thank you.
Committee Room 30, sound. 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 Committee Room 30,